West Leaders in West Hill. I have not heard from Charles, but hopefully he's not.
Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, January 30th, 2025. We have 12 bills on the docket. I see Senator Simonaire is here, so we're going to start off with Senate Bill 280. Senator Simonaire, welcome. And Mr. Morris, are you coming up for that? Is Chief Morris here? I saw him earlier today. All right, Senator.
Thank you. For the record, Senator Brian Simonaire presenting Senate Bill 280. By now, you're familiar with my military package, and this is one of the 8 bills that supports it. I've asked my panel to submit written testimony to make it quick for the committee, so please take a look at all the favorable support. As we discussed in the previous hearing on this topic, this package restructures the Maryland military law. It also creates equal treatment across the whole law. Specifically for Senate Bill 280, it deals with different articles such as public safety, criminal law, courts and judicial proceedings, and others. And what this does is it brings those standard definitions and structures in. It takes care of the equal treatment mainly by replacing armed forces with uniform services. In the public safety, there's quite a few places we left armed forces in there because it was appropriate only to that military branch. I'll give you a couple examples. In the clerk of the court, they exempt some fees for armed forces. We just apply that to all 8 branches. The courthouse dog program for veterans, that would apply to all. There's also a provision of unlawful wearing of uniform. We exempt PHS and NOAA in that as well. And there's some prohibitions where they can't deny you access to amusement parks if you're wearing a uniform. That would go to all 8 branches. So that's basically what this bill does. We have amendments, as we talked last time, dealing with veterans, where we're working with the governor's office and the department. I noticed yesterday there was a drafting error where they left out 1 digit when they're talking about the jury exemptions. And then as we talked about last time, we thought the federal definition had honorable discharge in it, and it doesn't. It says other than honorable, dishonorable. So again, not trying to change underlying policy. We have amendments to restore honorable back every place it was in existing law. One example of how it's a little different. Right now, Armed Forces has an exemption to go to jury duty in our state and other states. NOAA has that same exception, but PH does not. So we put in just those 7 branches as it applied to them. And with that, I will ask for your favorable consideration.
Here. Good afternoon, Mr. Chair, members of the committee. Dave Morris, Chief of Police for the town of Cheverly, here representing the Maryland Chiefs and Sheriffs Association in support of this Senate bill with the amendments that have already been articulated by Senator Simonaire. Certainly this is in light of this particular bill and the other bills that the Senator has introduced as it relates to our veterans, it's a somber day indeed with the tragic loss of a civilian and military life over D.C. last night. And we certainly want to keep the families of those who have lost loved ones in our prayers. We know that Senator Simonaire has sponsored a number of bills designed to enhance the quality of life and services for our veterans, and we thank you for that, Senator. The reinserting the small but meaningful word honorable or honorably into the definition, particularly as it pertains to the certification of law enforcement officers in our state, we think applies to the intrinsic values that we hold dear, both as veterans as well as law enforcement officers in the state of Maryland. So again, we thank you. And on a personal note, and Mr. Chair, you will appreciate this, as a veteran of the United States Navy, I will say that the United States Navy taught me in 4 years what it took my parents over 18 years to try to teach me, and that was to behave myself. So we'd ask for a favorable report on this bill. Thank you.
Go Navy. All right. Questions from the committee? All right, seeing none, thank you very much. Thank you all. Thank you. With that, that'll conclude the hearing for Senate Bill 280. We'll now move on to Senate Bill 273. Senator Brooks, welcome back.
as peace officer and protective orders, military protection orders. The purpose of this bill is to close two gaps when it comes to protecting victims of abuse and harassment in Maryland. First, the bill allows judges to take into consideration the existence of a military peace order, it's called an MPO, when hearing cases for temporary relief. Second, the bill establishes a line of communication between civilian and military law enforcement when service members violates their MPOs. Temporary peace and protective orders exist to provide Marylanders immediate protection from harm, harassment, and/or abuse. If a judge finds reasonable grounds to believe that the respondent has committed and/or likely to commit future harm against a petitioner, then the judge may issue a temporary peace order or protective order pending full adjudication. Similarly, an MPO is an order issued by a commanding officer to protect a victim of alleged abuse, harassment, or threats by restricting the action and movement of the accused member. When MPOs function like temporary peace and protective orders, they are not subject to enforcement by civilian authorities outside of a military installation. This creates an unintended gap in protecting victims of harassment and or abuse in other states. Moreover, Maryland judges are also not explicitly allowed to consider whether or not an individual has an MPO when issuing temporary peace and protective orders against them. SB 273 closes both of these gaps by explicitly allowing judges to consider an MPO in a temporary peace or protective order hearing if the MPO was issued for a similar offense against the same person. Additionally, the bill also requires Maryland law enforcement to notify military law enforcement if they have probable cause to believe that an individual has violated an MPO. To clarify, Maryland judges will not be required to issue a temporary peace or protective order if an individual has an MPO. Additionally, the bill does not require Maryland law enforcement to enforce an MPO. SB 273 simply informs the military if a service member has violated an MPO while off a military installation and allows judges to consider an MPO when determining whether or not to issue a temporary peace and or protective order. Through the implementation of interpretational violence policies at the state level, we empower victims, deter offenders, and create an environment for military families that is conducive to resilience and readiness. For that reason, I am requesting a favorable report on SB 273. And my panel is here. Okay, yeah, okay. Okay, Chair. Mm-hmm. Okay,
Good afternoon. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office, and I co-chair the Maryland State's Attorneys Association Special Victims Legislative Committee. I'm here on behalf of the MSAA in support of SB 273. This bill does ensure survivors will receive uninterrupted protection, even if they move between military bases or civilian jurisdiction. I did confer with our counterparts in the military agencies, and they did state that we've had several incidents. In one case, a DV case, an incident happened on post. The victim moved off post, had a military protective order, and the victim called 911. But because the defendant was following her, the sheriffs declined to do anything because the MPO was not enforceable. Similarly, there was another sexual assault case where there was an MPO. After the case was charged, the defendant kept driving in front of the victim's house to intimidate her. And again, local law enforcement was unable to do anything any further. Finally, there was a stalking case where there was was an MPO, no civil protection order was in place, and the defendant ended up breaking into the victim's home. Nationally, we see cases like this where there were effective MPOs in place. Most recently, the murder-suicide in Georgia, the victim was not able to get a civilian protective order. MSAA supports SB 273. We believe that this will help victims who fully don't understand that an MPO is not going to protect them when they are off the military base. I spoke to our local law enforcement in Frederick County, and they also agreed that the necessary notification would be very effective, because even if the victim calls for help and there is an MPO in place, there was no mechanism for alerting that agency that there might be a violation order. So on behalf of the MSAA, we ask for a favorable report.
Good afternoon, Mr. Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in strong support of Senate Bill 273. Thank you, Senator Brooks and Senator Jackson, for introducing this important legislation. The Maryland Coalition Against Sexual Assault is the home to the Sexual Assault Legal Institute, where we seek protective orders and peace orders for survivors all across the state. As you know, there are 11 active military bases and installations in Maryland, plus many of you who have served and are out and about. And you know, this bill is really just information sharing, and it clarifies an area of great confusion. We have survivors of sexual assault, survivors who are the parents of victims of child abuse. We have intimate partner violence survivors who have military protective orders. They don't realize that they're not enforceable. In the civilian side, we have people on the military bases who also have some reservations sometimes about the civil orders. We also have the judges who don't necessarily always feel comfortable considering the military protective order. They're unsure of the due process requirements of commanders who issue these orders, and they really need this support in the law to be able to share important information. It's not that complicated of a bill, but it's really necessary to protect our military spouses, our military families, and our military members. So we ask for a favorable report.
All right, thank you very much. Senator Henson has a question.
Thank you, Mr. Chairman. My question is for Ms. Jordan. Good afternoon.
Good afternoon.
It is the afternoon. My question surrounds the implementation of it. I'm glad to see the testimony from the network to understand the perspective there. And in my years as a practitioner in domestic violence cases, I found that sometimes judges were very hesitant to issue orders against our service members. There's rightfully a great deal of respect for their service. Judges didn't want to do anything that would stand in the way of someone being able to be deployed or serve their country in the capacity that's necessary for that member. Do you think that if judges know there is a military protective order, could that have the effect of them saying, this has been handled and resolved, I don't need to have this civilian peace or protective order, now that I've been able to consider this knowledge, let me throw out what's in front of me and let's rely on the order that they've already received?
You know, I think that that is part of what's happening right now, is that there's not that understanding on the bench sometimes that the military order is not enforceable in the civilian world. And of course, as you know from your own practice, that the military member might also be the one who needs the civil protective order. They might be the one living in our community. So it's important both for the military members who have an order against them, but also for those who are seeking an order. So I think it's education and support all around the system, and so very much needed.
So the thinking is, if this is formalized as something the courts can consider, that creates the opportunity to perhaps educate the judge to understand what limitations exist with the military order so that they get the need as to why the civilian order is necessary as well.
Correct.
Okay.
Yes, thank you.
I appreciate it. Thank you. Thank you, Mr. Chair.
All right, further questions from the committee? All right, so we have one more person joining us virtually. Are they in the room? Christopher Arnold? In favor. don't see him on there. All right, Mr. Arnold, welcome. Good to see you again.
Good afternoon, Chairman. Great to be back in front of Judicial Proceedings. Christopher Arnold, the Mid-Atlantic Region Liaison at the United States Department of Defense State Liaison Office, operating under the direction of the Undersecretary for Personnel and Readiness. As you've heard, the military protection orders are MPOs, as we call them, require service members to stay away from victims of alleged abuse or harassment. Currently, these orders are only enforceable on the installation, which creates a dangerous gap when service members are off base, where they spend most of their time. Senate Bill 273 addresses this gap in two crucial ways. First, it allows judges to consider existing MPOs when deciding to grant the Maryland civilian temporary peace order or temporary protection order, and it gives the judges important context about patterns of concerning behavior. Second, it requires law enforcement to notify the relevant authorities on base when they have probable cause to believe that a service member has violated both a Maryland civilian order and an MPO, which improves coordination between civilian and military authorities. This bill closes the dangerous jurisdictional gaps that abusers exploit. And when a victim musters the courage to get protection on base, that protection shouldn't vanish the moment they step off of it. So we appreciate Senator Brooks and the Veterans Caucus for bringing this common sense measure to help protect victims of sexual abuse and domestic abuse while improving coordination between military and civilian authorities forward. And Chairman, we always appreciate the opportunity to appear before your committee. Thank you.
Excellent. Thank you very much, Mr. Arnold. Questions from the committee? All right, seeing none, thank you all very much. With that, that'll end the hearing for Senate Bill 273. We'll now move on to Senate. Thank you very much, Senator. We'll now move on to Senator Reedy with Senate Bill 336. Welcome back.
Thank you, Mr. Chairman. It's really I mean this, it's always an honor to be before you all here in the Judicial Proceedings Committee. Senator Justin Reedy for the record, representing District 5. Here before you on a bill that I'm not going to spend a lot of time because you all have done the work to get this issue passed through the Senate before. You've never passed my bill totally clean, but you've tied it into some other things, and I, in all seriousness, appreciate that this committee has taken this issue seriously. Presenting legislation, Mr. Chairman, Senate Bill 336, which is the Gun Theft Felony Act of 2025. Senate Bill 336 would exclude theft of a firearm from the general statute and classify theft of a firearm as a felony offense. First conviction would impose a 5-year imprisonment and or $1,000 fine. A second conviction would impose up to 10 years and a $2,500 fine. And because there's some folks on the committee that are newer, just to be clear why this is an issue in a bill, we've done a lot dealing with firearms and guns in this state. Some of it I've supported. There's a lot of things I haven't supported related to gun control. But one thing we've left out is we've made it extremely difficult for law-abiding citizens to purchase, to obtain firearms. That's been a policy decision by the General Assembly, and I frankly, at times, haven't supported how far we've gone on that, but we have. But we still have in our law that if you go and steal and possess a firearm illegally that you've stolen, we don't treat that any different unless the value is above the theft statute, $1,500. We don't treat it any different as if you stole a TV. And I think that's wrong, and I think people agree that someone who steals a firearm should be treated, it's very serious. You're not stealing a firearm for any good intentions. And so what this bill tries to do is just elevate the crime to the level of what it is, which is a dangerous act to obtain a deadly weapon illegally. So between 2017 and 2021, the ATF has had more than 4,500 firearms reported stolen from private citizens in Maryland. And I think about what I have in my testimony, about 23% of all firearms that were reported stolen were recovered, but many were not. So it's an issue. It's not a one-off. There are thousands of guns that are stolen in our state and are being carried around in traffic. So the last poll that we did on this, we entered a question in the Gonzales poll a couple of years ago, and 89% of Marylanders supported having a felony to possess a stolen firearm. Our communities want stronger punishments for those who commit firearm crimes with firearms and certainly steal a firearm with that kind of ill intent. So I would ask for a favorable report on Senate Bill 336, and happy to answer any questions and appreciate the time.
Excellent. Thank you very much, Senator. Senator James has a question.
Thank you. I want to thank you for bringing this bill back. You may or may not know that I had a catastrophic house fire, and immediately, and this just happened, so immediately after that, one of the first things we had to do is we had quite a number of guns. So they were not secure. So we got them to other places. But just to give a sense of how extraordinary it is about people laser focused on this, one of the persons that we asked to protect this, a friend of theirs became aware that those guns were there and proceeded to break in and steal them. So it is, they didn't go in that house, they didn't steal another thing. The only thing they wanted were these firearms. And later I learned from law enforcement, for no good purpose and not to resell them for, to pay rent. This was a very serious crime, and law enforcement was communicating to me how frustrated they were because the law doesn't seem to be aligned with the seriousness with which not only law enforcement views this, but citizens do as well. I thought we passed this bill. So I thought we got this into law already. Senator, what happened? Did it just not make it?
So I don't have the entire tick-tock of what happened, but I know it was added into some bills when we were working on firearm crime last year and juvenile crime. It wasn't in the juvenile bill, but it was part of that whole discussion.
Yeah.
Then if I remember correctly, the House got our package.
Yeah.
They did some things, stripped some things out, and it came back over as part of a bill that was going to let drug kingpins get out of jail more easily. But we ended up not passing the bill, period. So
That's what, okay.
I'd like us to quit. Hopefully we can make some progress on this issue.
The point is the Senate, my recollection is
Yes.
the Senate moved this language in some form, and then it got caught up in
the wash a little bit, yeah.
All right. Thank you. I think it's a serious problem, and it needs a serious answer, so I thank you.
Thank you. The bill, actually, it was a sine die. It was on third reader, and I won't go directly into the individuals involved, but
yes,
it
I
was
think I
on third
remember.
ready, and then it got filibustered in the House. You remember? If you remember that, this is the Senate now. I know I'm saying, but you were there when it's and it.
Thank you for
It
reminding
was
me.
we're not going to just play back the tape. You'll see what happened.
Well,
But,
I remembered it got back to us, and somebody in our body was upset about it. So
no,
I
we
can't
passed
remember.
it, and then it went back.
over
It
to
was on
them.
third reader in the House, and a certain member.
Well, because it was a mixed. From my perspective, it was a bit of a mixed bag of.
It was, but
in
the
bill.
issue was that they were mad that it was theft and not possession, and you can't possess something without stealing it.
Right.
So it's easier to prove possession than it is theft. And in that mix, they were mad that theft wasn't in there, even though possession was. But that was last year's problem, so we'll go for
Well,
it.
maybe we can work it out because
Yeah.
I do think it's an important issue. It's kind of a loophole, in my opinion. You know, I had a group of people in my office today talking to me about gun control measures, and we talked about this bill. And I asked them to look at this and hopefully support it. But it's like we've done a lot. The state has done a lot about, firearms. It seems like this is a glaring loophole. So I know we've tried to close it. So hopefully we can get it done this year. Thank you, Mr. Chairman.
Thank you. Well, excellent. Thank you, Senator. Further questions for the Senator? I think we do have two people signed up in favor. We have Carla Mooney and then Mark Pennick. Is Mark Pennick here?
He might be in Ways and Means still.
Okay.
Hello, my name is Carla Mooney. I'm from District 29C. I'm Director of Women for Gun Rights in Maryland. I came in in support of this because all of the previous years I have tried to be a voice of reason and help get this through. And I see that this particular committee is for this, and I do appreciate that greatly. I think the biggest thing that I wanted to remind people is if somebody has a simple theft because it's under $1,500, it doesn't even make them a prohibited person from buying a gun. So not only did they steal one and get away with it, now they can go buy one if they want to. I really think this bill needs to pass to protect us. For those of us who have legally gone through the process, safety and security is paramount, and as an instructor, I teach that very highly and emphasize that, whether it be in the home or elsewhere. But I appreciate you guys' support in this, and appreciate that Senator Reedy hasn't given up, because this is really a big step that we need in the state of Maryland. I appreciate your time today. Thank you.
Yeah, I just wanted to say thank you, ma'am, for testifying, and thank you to the senator for bringing this bill. As the senator mentioned, it's Moms Demand Action Day here in Annapolis, and I don't think they've taken official position on this bill, but every time I talk to that organization and tell them about this legislation, all I receive back in support is supportive statements about how important this is. So it's not every day that Moms Demand Action and Women for Gun Rights speak generally in favor of legislation, and I think that speaks to the importance of this legislation. Thank you, Senator, for bringing it.
Thank you, Mr. Chairman. If I may ask the witness, I'm trying to understand safe storage and what it looks like. I'll confess, I've never been in the pursuit of trying to steal a firearm. So when I try to map out in my mind what that looks like, how difficult of a task is that, how do we jive our safe storage responsibilities and our safe storage laws with theft of a firearm as well? So can you talk me through best practices on safe storage?
I can, absolutely. So at home, we want to have something that is secure in the home, meaning something that can't be easily walked out with. Something like that can be the vaults that are secured to a piece of furniture or into the wall, or a safe that's too heavy to throw over somebody's shoulder and walk out with. So at home, that's not a really difficult task. It's for the almost 200 concealed carry holders that we have a task that's a little more important. I believe that most of the gun thefts come from concealed carry holder going to a place that is a prohibited place and having to download into their vehicle into a lockbox and securing it there. So thefts out of the vehicles tends to be a difficult task to protect from. For some, I don't find it difficult to buy a gun vault that connects to my car. I have a key that connects to the side of my bag. I can easily use a key to download safely and feel secure that not only is my car locked, but the vault is locked and secured to the car. But there is a step that needs to be taken in every responsible gun owner, and that is, if you have to go someplace where your gun is not allowed, that you either plan ahead and don't carry it that day, or you plan ahead and have a vault to secure it in your vehicle. But at home, those thefts, most of the time, I believe those thefts are someone whose home was broke into and their gun might have been the one on the headboard or next to the bed. In my home, as a firearms instructor, I have multiple safes to secure that particular firearm because I'm of the option pants on, guns on, so they can't steal it. They're going to have to take me. So when I'm asleep is the only time that that's not the case. It is a difficult task for someone new to guns, but you can secure it with what it comes with. A lot of the times the case that it comes with. If it doesn't, a vault costs $30 to $40. And I know that's where Mark Pennick is talking about the tax refund for purchase of a safe or a vault up to $200 per person. I'm sure that's where he's at. So safety and security is important, but in the home, it can be something as simple as a small safe that is secured to your wall or to a cabinet, having keys or combination locks. The options are endless. We do talk through that every single gun owner that we see as an instructor.
Thank you for your expertise. Thank you, Mr. Chair.
Further questions for the committee, from the committee? All right. Thank you very much, Senator. Thank you. Thank you, Ms. Moody. And with that, that'll end the hearing for Senate Bill 336. We'll now move on to Senator Love with Senate Bill 348.
Good afternoon, Mr. Chair, Mr. Vice Chair, esteemed members of JPR. Sarah Love here to present SB 348, Visual Surveillance with Prurient Interest, Private Place. I think we've talked about this statute earlier this session. SB 348 would add a residence to the list of places in which a person can have a reasonable expectation of privacy and in which someone cannot conduct visual surveillance with a prurient interest. This may sound familiar, and that is because it is. The Vice Chair had this bill co-sponsored by Senator Folden last session. So currently, just to remind you all what we're talking about, Maryland law provides that a person may not, with prurient interest, conduct or procure another to conduct visual surveillance of an individual in a private place without the consent of the individual. And then the law defines the private place as a room in which a person can reasonably be expected to fully or partially disrobe and has a reasonable expectation of privacy. And then it lists 9 categories of places that are included in this definition, such as an office, a business, a theater, a school, a bank. What it doesn't list is a residence. I don't know why it doesn't list a residence. I wasn't there then. Perhaps it was just so obvious that, you know, those of us who came before those of us in this room didn't think they needed to list it. But because it isn't there, it is now a giant gaping hole in the statute. And let me give you a couple of examples. Last session, you may remember that the Vice Chair came up with a hypothetical. So a woman brings a college friend home. She stays in the guest room. The husband, for his own sexual gratification, puts a video in there and videotapes the woman. Not covered under this statute. And last session, we heard testimony about a parent videotaping their child in the bathroom for their own sexual gratification. Not covered under this statute. That is absolutely abhorrent, and we need to fix that. So the only other thing I want to add is that a couple questions came up last year about a Ring camera or another camera that may be in the house for security reasons. Those aren't covered because you're not putting them there with a prurient interest. So, you know, the security camera may inadvertently pick up teenagers doing something that they might, you know, you don't want to know and they probably shouldn't be doing, but it wasn't placed there to conduct visual surveillance with a prurient interest. Right now, there are a lot of cameras in a lot of businesses that may catch something that people shouldn't be doing, but they're legal because they weren't put there with a prurient interest. So I hope that question has been put to rest. And with that, I will turn it over to my panel.
Good afternoon. My name is Taryn Quaitman, and it's a privilege to share my story with you today. On March 24th, 2023, I have been happily living for more than a year and a half with my best friend Kimberly and her partner of 10 years, James. Yet just one day later, I stood in the shower, naked and petrified, as the bathroom door opened and the camera lenses of James's iPhone slid into view. This act was not isolated. Kimberly later discovered a note on James's phone unveiling video after video of me in the shower and on the toilet. I went to the police hopeful that although I failed to protect myself for the 15+ months James had filmed me, surely the law would. But 17 months later, James was found not guilty on every count of visual surveillance. There are a minimum of 29 videos and 65 images of me, yet James's predatory behavior was disregarded due to a semantic technicality. A precedent was set. In Maryland, recording someone naked in their own bathroom without consent does not violate the visual surveillance law. The rationale: the law does not explicitly list a residential bathroom, presumably one of the most private places imaginable, as a private place. The law failed to protect me, and it will fail to protect future victims, but it doesn't have to, and there's a beautiful opportunity to make it better. SB 348 is fair. It clarifies that the given list of private places is non-exhaustive and eliminates ambiguity. The bathroom in your home is private. I urge you to issue a favorable report on SB 348 and to consider the impact that will come from such a simple change. Thank you.
Good afternoon. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office and co-chair, along with Joyce King, of the Maryland State's Attorney's Office's, the Maryland State's Attorneys Association Special Victims Legislative Subcommittee. So I'm testifying on behalf of my office as well as on behalf of the MSAA in support of Senate Bill 348. I want to first of all thank Ms. Quaitman for coming in this morning or this afternoon and speaking to you. I spoke to her in the hall before we came in here, and I said, look, the senators are going to want to hear from you. They hear from me all the time about different bills, and while my voice certainly is heard, her voice shines even louder because you're presented with a specific example that happened within the last year in Montgomery County where a judge interpreted this law in a way that is not inconsistent with how the law is currently written. The judge said, private place in a home is not specifically enumerated. Therefore, we are not going to find this defendant guilty of visual surveillance with prurient interest in this residential bathroom. Now, I want to point out that not only did Senator Love add residence to the language, but this is a little bit different than last year because she also suggested fantastically that it should say, instead of saying in one of these locations, that it should say including. Really what the guiding principle should be is that someone has a reasonable belief in their privacy in this location. So the language of the statute and the way that it's worded now will be inclusive, but will also not pose the problems, as Senator Love pointed out, regarding Ring cameras and that sort of thing. Lastly, I would note that in the form that this bill was submitted last year, it also included an enhanced penalty for visual surveillance with prurient interest of a minor. That is not part of this year's current statute, and if that had been the holdup, I would really encourage you to swiftly move this bill forward, close this gap in the law, and I would urge you to issue a favorable report for Senate Bill 348. Thank you.
Got it. Thank you both. Thank you all very much. Questions from the committee? Senator James.
Thank you so much for coming. I mean, it's got to be very difficult. Was the perpetrator of this awful conduct, criminal conduct, was there any other way that he was held accountable? I understand we could not do it for technical reasons under this statute, and that's what we've got to fix. But I just, if you don't mind sharing that, just was there another way for that, or if the state's attorney wants to address it?
Yeah. So,
sorry, you have to stand back up again.
Sorry. Yes, so ultimately there were 23 charges of visual surveillance that were issued. There was one charge or one count, sorry if my terminology is not accurate, of stalking that was issued. The defendant was found guilty of one count of stalking, and all of the visual surveillance charges were eliminated.
But again, thank you very much. I'm glad there was some modest way that the person was held accountable. I don't know what the penalties are for that particular charge, in this case, and whether he had a prior stuff. Do you want to just address that real quick?
So I just want to address that that he was convicted of stalking, which is a 5-year misdemeanor, which we've come before this body to address in other forms, not this year, but we'll be back.
Yeah.
But the reason that he was able to be convicted of the stalking was because of language this body added just a few years ago, that it can be a course of conduct meant to create emotional distress. And so that's what he was convicted under. But it's Stalking is a very difficult statute to prove. Fortunately, the court did find the defendant guilty of that. But again, we have 23 counts, which is really the essence of what this perpetrator did was the recordings, and he was exonerated for that. And so that's really where the concern is. And this is not isolated.
Nobody in this committee thinks, oh, we got him in another way. We were almost lucky, and it was the work of this committee probably that helped with that language.
Yes, it was.
But now we have another fix that we need. Okay,
Absolutely. Thank you,
Chair.
Senator James.
Yeah.
It's just, Alana, so section 3903 of the criminal law article, which is the camera surveillance, which carries the same penalty that you're offering here. It seems that it would have been applicable here for the surreptitious recording of another. So why was that not charged and or?
Which one?
So I personally didn't prosecute this
Yeah.
case, and so I can't necessarily speak to that, why that wasn't also charged. But I think really what we're looking at when we're looking at the prurient intent piece is why this is really where this squarely falls. And I think that, so again, I can't speak to why those weren't charged, and I appreciate that there's another law that may cover this conduct as well, but.
Yeah, because it seems like that's more elastic, because prurient intent is more difficult to prove than just surreptitiously recording someone without their knowledge. You know what I mean?
Yes.
It just seems like it's more elastic and more applicable. It would have been charged. I'm just wondering. I mean, I think this is a great idea, but I'm just wondering why that. It's because it's the same penalty that you're offering. So.
Absolutely, absolutely. And I actually can't tell you. All I know is how this particular loophole that the judge was so explicit about ended up infecting this young woman that's in here before us today. And it's a gap, and we've been trying to close this gap actually for a number of years. I think this may be the third, maybe fourth, thank you, Ms. King, the fourth time that this has been before this committee in some iteration, and that's why we're trying to really narrowly tailor it, because there's going to be, falling squarely here is really where we think this type of activity belongs.
Senator Sidnor.
Thank you. If I remember, one of the discussions around why we landed as we landed was a colleague talking about having cameras in his children's bedrooms or wherever, and not wanting or not believing that that should be criminalized. So I'm trying to understand, how does this not capture that activity of having having the Ring camera up? I know you say, well, it's about prurient intent, but that's facts. So I'm charged, and I have to prove that I didn't have that intent. And do you want people going through that whole?
Thank you for your question, Senator. The perpetrator has to act with a prurient intent in the process of the recording. Really, if you think about a Ring camera, it's an incidental recording because things are being recorded all the time. And a bedroom is not where you would necessarily expect the same kinds of things that you're going to expect in a shower or someone in the toilet. I guess if it's a small child where there's diaper changing, I just can't really envision a situation where we would be prosecuting under those circumstances, because I don't think the facts would ever support that. Although I appreciate what you're suggesting, Senator.
And why doesn't, that's on page 2 of the bill, line 16 and 17, where it talks about a private place, including a bedroom or a restroom. Could you explain what happened there? I mean.
So and actually Ms. Quaitman reminded me, because she was there and I wasn't at the trial on this matter. So I want to address two things. Number one, the court found that the definition of private place in this statute governed that section as well, and ended up saying that there was tension, so he was going to resolve it in favor of the defendant. So that's how that resolved. And then
tension,
there was.
Explain that. What do you mean tension? Help me out. There was tension between.
Tension between the sections of the law.
This section and the section that the chairman just noted, or which?
This section. I'm sorry, Senator. Right. Right. Thank you. There was tension between sub 1 and sub 2, and so the court found that, and thank you, Senator. The court, so there was a tension between 5(1) and 5(2).
Okay.
And the court basically, that argument was made, and the court said because there was tension between little one and little two, I'm going to resolve it in favor of the defendant, and I'm not going to let little two control, where it says including a bedroom, because it's not specifically included, residence is not specifically included.
But it says bedroom or restroom. I mean.
Yes, Your Honor. Yes, Senator, I guess what I'm saying is I'm telling you what the court did.
No, right.
And I don't agree with it. I don't agree with it. It doesn't make sense. No, this is what the court found, that there was tension between little one and little two, and he was going to resolve that tension in favor of the defendant and acquit the defendant. And he did the same thing, actually, Ms. Quaitman's reminding me, with respect to 903. The court actually, and I really appreciate her more direct knowledge, but I'll explain the legality of it because now it's refreshing my memory. In 903, as I recall, there's some language that says regardless of, and the court again found a tension with that and used the definition at 902 to control 903. If that makes sense. Because I think private place is also used in 903, if I'm correct, and use the definition in 902 to control what was happening in 903. So there actually were charges under 903, and I really appreciate that correction, and I apologize to this body for not having full grasp of the facts.
Was that judge's decision, was it in writing?
We believe it was the wrong decision, but
was it written?
No, not a written decision. No, it was a decision it was a circuit court from Montgomery County judicial decision.
Okay, thank you.
Right. Yeah. Right. And I think as Senator Love is pointing out to me, that this is not the first time that this law has been interpreted this way, which was the genesis of all of this coming up in the first place, is because this definition is just, it doesn't make sense that residence is not specifically delineated. Maybe it was so clear that it should include a residence or a residential bathroom that this body elected not to include it. But unfortunately, the court, and on more than one occasion, is reading it too narrowly, I guess I would suggest. Pardon me?
And I guess that's where I'm confused. I mean, a bathroom is a bathroom, whether it's in the residence or out in the public. A bathroom is a bathroom.
Agree.
So I'm not understanding why the judges.
Well, it actually says restroom in that little second one. So I think you can make an argument that, and it's been made that a restroom is not the bathroom in a residence. I mean, it's little words that end up making this kind of difference, and then end up affecting members of our community who are not made completely whole. Not that you can ever really be made completely whole by a criminal act, but who are not. The perpetrator's not brought to full justice, I guess I would submit.
I appreciate it. Thank you.
Thank you, Senator.
That was my last question. Last week, we had a hearing on a portion of the statute for the two-party consent statute. And there was a witness that came forward and said that his brother had been convicted of surveilling, in his house his claim was that it was for keeping an eye on some equipment. So we, tracked it down, and actually it was a little different than that. And so he was convicted of the felony under the two-party consent statute. So my question is, was there audio here? And if there was audio, was that charged as well?
I don't believe there was audio. Am I correct?
Like the videos had sound.
Okay.
But so all of that.
Right. So it was not charged in this case, Senator, but there was audio on the video, not the photographs, obviously, but the video, there was audio.
So that, in another case, that person got jammed up with a felony for doing similar activity.
Absolutely. And I guess we're talking about the facts of this particular case and how it played out and what statute makes the most sense. And when we're looking at sort of the gravamen of the offense in this case was the visual surveillance with prurient interest, recording his girlfriend's best friend taking a shower and on the toilet is visual surveillance with prurient interest. It really sort of, that's what it is in terms of gravamen of offense. So we're looking, again, this is we see as a very minor change to really close a gap and make this statute, really what I would submit is the intention of this statute was to include a private residence and bathroom. It doesn't make sense otherwise.
No, I agree. I guess my point is somewhat of an adjacent application of the two-party consent statute, but just understanding the importance of it is just,
yes.
And it would have potentially been applicable here. But all right.
Thank you.
Okay. Further questions from the committee? Seeing none, thank you all very much. All right, looks like that, with that, that'll conclude the hearing and the testimony for Senate Bill 348. We'll now move on to Senator Love with Senate Bill 274.
May I bring up my panel, Mr. Chair? Good afternoon, Mr. Chair, members of JPR. Sarah Love here to present to you SB 274, Child Victim Testimony in Child Abuse Cases. This bill addresses the topic of a child victim testifying against their abuser. Right now, in very limited circumstances, Maryland allows child victims to testify against their abuser at trial through closed circuit TV. These limited circumstances apply in only specific cases, including sexual abuse or physical abuse, defined as physical injury sustained by a minor as a result of cruel or inhuman treatment. It also only applies when the defendant is a parent, household member or family member, person who has permanent or temporary care or custody of the child, person who has responsibility for the supervision of the child, or a person who, because of their position or occupation, exercises authority over the child. So we are talking about horrific acts committed against a child by someone they trust. So under the law, a child victim can testify at the trial of their abuser outside of the courtroom through closed circuit TV in the presence of, among others, the defendant's attorney. And in order for this out-of-court testimony to occur, the judge must determine that the testimony by the child victim in the defendant's presence will result in the child's victim suffering such serious emotional distress that the child cannot reasonably communicate. And so what I'm here to talk to you about and what SB 274 addresses is that last phrase, the child cannot reasonably communicate. The problem is that that sets a bar so high that prosecutors have been unable to use it and child victims have been unable to testify via this mechanism. I mean, what does it mean to not reasonably be able to communicate? Must the child be rendered mute? Must they be so terrified that they hide under the table and whisper? What if they just sit there and they can barely talk but sort of talk? It's not clear, and so the judges are not comfortable in allowing it. And we have heard a number of cases in which children have either been forced to testify in such horrific circumstances, or they just are not able to testify at all, and that case is not able to be prosecuted. So this bill would strike the phrase cannot reasonably communicate and maintain the requirement that testifying in the presence of the defendant will result in the child victim suffering serious emotional distress. And I want to close with really the purpose of this statute is to balance not causing the child such serious emotional distress with the defendant's right to counsel. And by striking that language and keeping the rest of the statute, we really do balance those two important interests and rights. So with that, I ask for a favorable report and turn it over to my panel.
I'm Lauren Preem. I'm the mother of a child abuse survivor, a resident of Severna Park, and my daughter was only 8 years old when she was abused by her male teacher. She was simply attending school. She is now just 9 and in the middle of an ongoing criminal case. As a parent with no legal background, I've had a front row seat to how we ask way too much of our young children that are found in the position my daughter is in today. We will tell her one day soon that she has to sit on a witness stand directly in front of her abuser, who all but took her spirit, her trust, and certainly her safety. And we will ask to tell her most vulnerable story. We will tell her to pretend he's not really in the room, though every part of her body will be screaming that he's there, because he is still there. He's still there in her nightmares when she tries to sleep. She still feels like he's there when we have to drive by her old school, the school in the center of our town, the school at the end of her neighborhood where she used to ride her bike. The average person comes forward about their sexual abuse at age 52. My daughter was 8, she made it stop, and she did her job. Kids like her are doing their job in the face of great fear, and it is our job to provide an environment that fosters their protection. Even in great hands, pieces of the criminal process re-traumatize our children. It's inherent, I have watched it, I have cared for the aftermath of it. Each time they speak to a stranger about it, each time they have to relive it, each time there are questions, it's their own unique flashback that is often too soon in their healing journey. Because where we are right now is real time. These children are not 52 years old, they are not adults, they are children. And the only realistic hope here is to try to minimize their trauma in order to hold their abuser accountable for their crimes. Allowing testimony out of the line of sight of the abuser gives them this hope, a hope of felt safety that supports a very quality and thorough testimony. Their voice, no matter how small, deserves to be heard in an environment that fosters their protection. I believe it's our job to set them up for this success. Respectfully, I ask, don't we want these children to grow up and honor a system that protected them when it mattered and not scarred them further along the way? Thank you for your time.
Good afternoon. My name is Cheryl Grady, and I am a resident of Frederick County. I am the president of the Friends of the Child Advocacy Center of Frederick County, and I'm the mother of a child abuse survivor. I'm here today to respectfully request that you issue a favorable report on Senate Bill 274. If this process had been in place several years ago, my son would not have had to sit in the courtroom to testify against his abuser. As the victim in the trial, my son had to sit mere feet from the defendant, and it was the first time he had seen this person since being violently attacked, and he was only 11. My son had to face the emotional challenge of having to be questioned about his abuse in front of strangers while being watched by the person who abused him. It was made even harder given that my son has anxiety and he is on the autism spectrum, but he sat up there and he spoke his truth. What was most tragic to me that I was unable to be in the courtroom to support him because I was also a testifying witness in the trial. As a mom, it was the worst thing in the world to tell my son outside of a courtroom to be brave and then watch him walk away. To this day, even though he is now a young adult, he continues to say that this was the worst day of his life. He says that it was worse than the actual acts of abuse and assault that happened to him. To this day, I feel awful that in order to help my son seek justice, and even though he won, I had to subject him to even more trauma. And once again, he was only 11 years old. A young child should have the opportunity to testify to seek justice, and I understand the right of the accused to confront the accuser. However, it is very important for everyone to understand how much the process of justice can add to what is already going to be lifelong trauma. These children grow up, but it never goes away. My son's trauma was intensified by having to testify in front of his abuser. It required him to need months of therapy to prepare for the trial, and it also required months of therapy after the trial to heal from the trial, not just the abuse. Thank you so much for listening to my story.
Good afternoon, Joyce King on behalf of the Maryland States Attorneys Association, and I can't say it any better than these two women, and their experiences really echo the heart of this bill, that SB 274 really properly balances the confrontation clause with also the technological advances. This is a modernization bill, the expansion of Zoom meetings and technology. This is now normalized in our society, and we do not believe that it is an affront to the confrontation clause. And I'd just like to emphasize what Senator Love already highlighted, that this statute only applies to very specific cases of child abuse cases where the defendant or the child respondent is a parent, family member, household member. I mean, these are significant relationships between the child victim and the defendant. And as you have heard, it is the most horrific experience and re-traumatizing experience to have to testify in front of that abuser. Ms. Feinstein and I are here for further questions, but I believe that they have really excellently covered the spirit of this bill, and we ask for a favorable report.
Good afternoon again. Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. And on behalf of my office and the Maryland State's Attorneys Association, I want to just add a couple of points. I've personally prosecuted hundreds of child sexual abuse cases and have supervised the division in my office that prosecutes these cases, sexual and physical abuse cases. And in those cases, when we prep children to testify, we try to bring them into the courtroom in advance. And I will tell you that I have never seen a situation, either my own cases or the caseload of my team, where we've successfully been able to meet the hurdle of someone being rendered unable to communicate. Because if they can say anything, you're not going to make that hurdle of unable to reasonably communicate, and I've tried. And I can tell you what we do instead. We talk with the kids in advance. I walk them into the courtroom, literally using my body as a shield between the child and the perpetrator, so that I walk in between them. The defendant may be sitting to my left. The child is moving up to the witness stand on my right. I will walk them all the way to the witness stand, from the door all the way to the witness stand. I will talk to them about where they should look when they testify. We try to have a support person sitting in the courtroom that they can look at, that they can look at, the state's attorney who's asking the questions. But they still have to look at the perpetrator in order to identify them in the courtroom. So there has to be at least that one look. And it's really being in the presence. We do all these other things to try to protect them, but at the end of the day, they're still in the presence of the person that perpetrated this abuse on them. And that in and of itself, I can tell you, has created and creates severe emotional distress for many of these children. We've had children that have become suicidal afterwards. We've had children that have had to be taken on an emergency evaluation petition to the hospital immediately after testifying, children who collapse on the stand. This is a reasonable bill. It shouldn't have to go to the extent where the child can't speak a word. It should be rendered instead this standard of emotional distress, severe emotional distress. Thank you for your time. I urge a favorable report.
She was first. Thank you. And thank you. I was asked to do this bill last year, and state's attorneys might remember that. But there was a difference between the House language and what I thought was appropriate language for the Senate, so I didn't follow through. But my memory is that, and so I support this bill in concept, no doubt about it. But what I recall, to understand and that you have the right to confront your accusers, I thought that the language that we had come upon was to at least have, a mental health expert, make the determination that testifying in the presence of the defendant would cause serious emotional distress. And we might have even had a little more enhanced language, because honestly, testifying at all is very distressful for everyone, and I can't imagine how bad it is for a child. But I thought we had a little more language, involving a mental health expert with children, just, because to me, this is a lower bar. It almost, to me, this bill now drafted is pretty much the child will never testify in the presence of the defendant, because I can't imagine that it would be hard to say that they're having serious emotional distress. And the bill doesn't address who would decide that. There's no process. I don't know if just the parent or state's attorney would say that. I don't know how the defendant or their counsel would challenge that. So I'm all for this bill in the sense of protecting children. But maybe I'm missing something. I feel like maybe it's an incomplete bill at this point. Could you speak to that?
Absolutely, Senator James. The bill actually does speak to all of the elements that you're speaking about. The bill in subsection C talks about how that determination is made. And it says that the court may observe and question the child victim inside or outside the courtroom. And I can tell you, in looking at the case law, the case law speaks very favorably towards always having the court speak to the child in advance, outside of the presence of the defendant. And also, and, it's not an or, it's and hear the testimony of a parent or custodian of the child victim or other person, including a person who has dealt with the child victim in a therapeutic setting. So it is, that provision is already there. And then it's going to be the court will decide the weight of the, the child victim's parent or caregiver versus the mental health, knowing that a mental health professional is someone specifically specified or mentioned in the statute. And I can tell you that one case where I tried it, I did have a mental health specialist, a therapist available to testify about the child's emotional distress. We've also tried to get records from therapeutic providers, although that's a careful balance because you don't want to dive into the child's full mental health history. But then there's also a process in which the testimony would actually occur, and the defense attorney is present in the room with the child. It's only the defendant who's not present, right? So
that wasn't my question.
Sure.
I'm just trying to understand why we wouldn't at least require a therapist or some level of expertise to do this. I know as a mother that I would absolutely say this would cause my child suffering, because it would. But I'm just trying to balance the interests of having maybe a neutral third-party expert, because then you've got a defense counsel having to cross-examine or ask questions of a parent. I just don't know how probative that is. And I think our language was different last year, but maybe you all rethought it and this is what you want. But I just have a little concern there with not having the language that I think we were working on last year.
So a couple of things. First of all, I think the language was the same last year. I don't recall there being a difference, but basically we would have to call an expert, I think, to get over the threshold. With one exception, here's the situation. A lot of these kids who are victimized don't have what our amazing moms who are here today did for their kids to support them, to get them into therapy. We a lot of times have the non-offending caregiver or parent supporting the abuser. And so the question of whether that child is in therapy, they may still be in the custody of their parent. It may not even be known fully what that non-offending parent is doing with respect to the child. We've had plenty of parents that have refused to bring their kids to therapy.
I didn't suggest the child had to be in therapy. I was suggesting that a expert provide the court the opinion whether the child will suffer severe emotional distress.
I think that will absolutely be the best practice. I agree with you.
Why isn't it in the statute?
Well, I think it's an including, and I guess I'll defer to Senator Love as to whether that's something that she wants to specifically delineate, but I appreciate that question.
No, thank you, Mr. Chairman. Thank you.
Thank you, Mr. Chair. So I don't know if Joyce, if you want to come up, Ms. King. So I guess I'm going to go down a little bit of a different path than what my colleague did, and that being that I've been on these incidents as a police officer, I've seen the emotional distress suffered by the children. It's a visible, obvious thing. I guess when I read it, I'm looking at it more through the lens of if we have a child 8 years old, 11 years old, whatever this is, as the victim, that experience is a very distressing experience for them. In my opinion, that we're bringing this forward. So I guess what I'm asking, when I look at it through that lens of the responders and seeing that and the parents who see it, and then in the subsection C with the subset of 1 and 2, I think that encapsulates what we're trying to talk about, if I'm not mistaken, because of the experience is the stressor on the child, because they are a child victim. So I would ask that, are we looking at, and we're not, and there's no provision in here that doesn't say when we're doing the interview with the child that the defense attorney is there to be able to ask questions, right?
Correct.
And that is then, after that back and forth with the questioning is completed, it's closed, and then it's later presented to a jury or
It's live streamed into the courtroom.
oh, it's live streamed. Oh, okay, so it would be live streamed the entire time. And then what would we do? Take a break, and then the attorney would then come in back, the defense attorney would come back in, and the trial would continue from there?
Correct.
Yeah, I mean, as I look at it through a law enforcement lens, I see it as the serious emotional distress is the act itself, and that we should be looking at, how the child is affected by these, because these are about child victims, and a part of their body, their being, has been violated. And it's a difficult thing for them to talk about with their parents, law enforcement, or anybody in a private setting, let alone in a because being in court, it can be intimidating for adults. So I don't know if you want to add on to that or
No,
explain that a
that's
little further.
a very valid point, and I think your interpretation is right, and thank you for clarifying for those that are not familiar with CCTV or closed circuit. This isn't a meeting that happens and then we go back to court. It's real time. It's casted into the courtroom. But with regards to subsection C1, we did want to clarify the analysis that the court takes. While everyone understands that when a child is abused, that is without a doubt a traumatic event and causes serious emotional distress, but the analysis that the court is taking is not the impact of the event itself, but rather whether testifying in court would add on to that. So it's a little nuanced, and I would also say that I know that the fear is that this is going to open the gates and that every child victim is never going to have to testify in court. And based on our experience with litigating these before the bench, we would wholeheartedly disagree, as well as there are a lot of child victims that want to testify in court and have their day in court, so we would never prohibit that either.
Yeah, that's what I wanted to point out. Thank you for bringing that up, is that we're not prohibiting them from being able to do that if they want to face their accuser.
Correct.
But the part of I guess what I'm trying to figure out is what is so complex about this idea? Is it that the defendant has the right to face their accuser? That's the one thing that's
Physical proximity, that's it.
It's physical proximity. So being able to literally see them versus being in an adjacent room doing
Well, they'll still be able to see them, so it's really about being seen and facing them, and that's why, correct.
So I'm asking, as a legal expert, and me being just no legal expert, but one that carries out the law, what is the problem with this language and as far as testimony goes and the rules of evidence?
And that's exactly our argument. We don't believe that there is any obstruction as to the confrontation clause.
Are there any other states that have a similar language in place for juveniles, for child victims?
I believe we did do a 50-state study. We could follow up with the committee and send that.
Yeah, I mean, I think that would be very helpful with a lot of people. I mean, obviously, I'm in 1,000% of this. I don't think it changes anything as far as how the child testifies, or the only thing it does is, in my opinion, would be having to physically face that person that violated them, makes it the stressor on them all that much more difficult, and I don't think that's fair to them to re-victimize them through that. It's bad enough they have to testify through it and be questioned by a defense attorney, let alone face their accuser. So with that, I think this is a great bill, and I think it's time to move it. So thank you.
Thank you.
Thank you, Ms. King. I'm sorry. Could you, when is it determined that the child victim cannot reasonably communicate? What I mean is, does the child have to take the stand and then be frozen as an example, and then you stop the trial and make that determination? Where does that happen?
It's a pretrial motion, and when we had our SVU subcommittee that represents every jurisdiction, I don't think we had a single prosecutor that said that they had successfully utilized this statute. To our knowledge, it has not been utilized at all for that reason, because it is so high a burden that no one has been able to meet it.
Okay, thank you.
Questions from the committee? So, in the statute, it says child, not minor. Can you give us the distinction on that?
Thank you, Senator, and thank you to Ms. Jordan for the quick support. It's 16 versus 18, but I also think child is probably used here because it's consistent with, you can only use it in the sexual abuse of a minor when that's charged. So, but thank you, Ms. Jordan.
Excellent. Questions from the committee? All right. Seeing none, thank you all very much. That'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and I think we have one witness signed up in opposition who's going to join us virtually. I think that's right. Tamara Stofa. Is she in the room? All right, welcome. All right, Ms. Stofa, you're up. Welcome.
Welcome. Thank you for having me and hearing from me this afternoon. My name is Tamara Stofa. I'm the District Public Defender for District 3, which is the 5 counties of the Upper Eastern Shore. I'm here today to ask the committee to do an unfavorable report on Senate Bill 274. The reason for that is the fundamental right to a fair trial for a defendant. The current law as it is set up does safeguard that fair right and is a safeguard to that. It requires the court to evaluate and interview the child and find that not only would there be emotional distress, but it would keep them from being reasonably able to communicate if they were to be in the courtroom with the defendant there. I think as what has been indicated is that it is very emotionally distressful for most people to have to testify. And so I think as a practical matter, eliminating the current safeguards in the law would allow most children to testify in this manner when they're under the age of 13. The reality of this is, as someone had said previously, that sometimes little words mean things or no words at all mean a lot. And so when you allow a child to testify, there's an inference that outside the presence of the defendant, there's an inference to the jury that there is a reason why we have to keep this child away from that defendant. And that is not fair when the child and the court has found that the child has an ability to be able to communicate to the jury. I would also remind the court of what seriousness of these offenses are. These are offenses that, if convicted, carry lifetime sex offender registry, lifetime supervision, and very serious penalties in the prison system. This is not about proximity. This is about the inference that it gives to the defendant and an unfair advantage in the trial. And the defendant is the one that is entitled to the fair trial. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you very much. All right, with that, that'll conclude the hearing for Senate Bill 274. We'll now move on to Senator Wallstreicher with Senate Bill 334. And you could bring up the panel, and Mr. Buttle would come up, and Mr. Gibson, come on up. Welcome.
Well, thank you, Mr. Chair. A quick prologue to Senate Bill 334, but it applies equally to the next bill, which is Senate Bill 326. Like many of you, I was deeply saddened and distressed about the midair crash yesterday between the Army helicopter and the civilian plane. And as much as I was saddened by that occurrence, I was also heartened by the incredible response by our men and women in uniform last night and this morning. I watched the press conference this morning, and you saw people in all sorts of uniform. You saw Army folks in their fatigues. You saw firefighters in their telltale red. You saw men and women in blue. And right now, in this very moment, there are first responders underneath icy water trying to recover the bodies of those who were killed and provide their family with closure and dignity. Men and women in uniform, whether they're fighting on behalf of our country or fighting to protect our communities, they just want two things. They want compensation that reflects the risks that they take, and they want policies from this legislature that help protect them and allow them to do their jobs. And that's what this next bill, Senate Bill 334, involves. We passed this bill last year unanimously. It kind of got caught up on sine die, but it's an easy lift. I know we have some new members, and so I'll briefly describe what it does. We have a hole in our current law related to malicious burning. When a firefighter is injured putting out a fire that was started maliciously and charged under our malicious burning statute, that injury cannot be attributed to the person who started that fire maliciously. The bill in front of you fills that hole. Like I mentioned, we passed it unanimously last year, I believe. There is a small difference this year where we use wording to better reflect the causation between the person who causes the fire and the death or serious physical injury of the firefighter who puts out the fire. And so that's on line 2 of page 2. And I think that language clarifies exactly what we're trying to do and avoids some of the more thorny questions that we had last year. With that, Mr. Chairman, I will defer to my witnesses and ask for a favorable report.
Good afternoon. My name is Rich Gibson. I'm the State's Attorney for Howard County, Maryland, and the President of the Maryland State's Attorneys Association. I'm here in both capacities asking you to hopefully give a favorable report to Senate Bill 334. I think we can all agree that the brave men and women who are employed as firefighters and first responders have inherently dangerous jobs. They risk their lives to protect the lives and property of others. Senate Bill 334 is a solution to a gap in existing law to better protect them when they respond to a fire that was set by another person maliciously. If someone maliciously sets fire to the property of a home or another, it is reasonable and foreseeable that there will be an emergency response required to extinguish that fire. And if a firefighter were harmed during that response, it's logical to say they would not have been there to get harmed but for responding to that malicious fire that was set. And therefore, the person who set that fire should face the foreseeable consequences of their criminal choice. In Howard County, it's not a theoretical issue. In Howard County, in the last 6 years, 5 firefighters have been injured in cases like this. Across the state, there have been 35 firefighters injured according to the ATF bomb and arson tracking system in cases like this. This law, Senate Bill 334, makes good sense, and it allows for an appropriate consequence when firefighters suffer an injury responding to criminal acts of another. On behalf of myself, the Howard County community, the prosecutors of the state of Maryland, I ask you to give Senate Bill 334 a favorable report. Thank you.
Good afternoon, Mr. Chairman. Jeff Buttle on behalf of the Professional Firefighters of Maryland. We represent approximately 10,000 active and retired firefighters and emergency medical services personnel who serve throughout the state of Maryland. Before I get into my remarks, I would also like to recognize we have a number of our fire and arson investigators that have traveled here from around the state of Maryland. If they could just stand and be recognized so the committee can see who they are. I know it's hard to see without them standing, but they've come in support of this bill as well. It's important to note, I think, that the crimes identified in this bill are criminal acts, and I think it's important to recognize that fraudulent or malicious burning are acts that are willful and malicious. And the bill also allows some deference for the judge to determine the amount of time that would be served by the person that's convicted of the underlying penalty, and also whether that is concurrent or consecutive. So it does allow for some leeway there for the judge to be able to make the determination. But we believe that if We have individuals that are engaging in criminal acts that are both willful and malicious, and one of our firefighters is either seriously injured or killed, that there should be an additional criminal penalty for that. We think that's fair, and it's reasonable and would serve as a deterrent, hopefully, for individuals from engaging in these acts in the first place, so that our firefighters are not even in the position where it is that we would have to respond to an emergency or to the scene of a fire that was set willfully or maliciously. With that, Mr. Chairman, I encourage a favorable report, and we're certainly happy to work with the committee as necessary on the passage of this bill. Thank you.
Questions from the committee? Well, Senator, thank you for bringing the bill, and Mr. Buttle and Mr. Gibson, thank you both for working in the interim on this. It's my commitment that from me to you that we'll get this on a voting list and move this out of here expeditiously. And thank you for your commitment and your work to our community. So thank you very much. Excellent. Yeah, absolutely. Senator Fulton.
I want to thank you all for coming down. This is an important piece of legislation. As in the public safety arena, we far too many times allow things to happen that are leading up to criminal acts that lead up to the injuries of our first responders. So I do appreciate you, Senator, bringing the bill. And with that, I'll just say, isn't that so? Thank you.
Looks like you're going to have a bipartisan vote on this bill when it's on the list next week. All right. Excellent. Thank you all very much. With that, that will end the hearing for Senate Bill 334. We'll now move on to Senate Bill 326.
Thank you, Mr. Chairman. And as my witnesses are coming up, let me just say for the previous bill, as you say frequently, Mr. Chairman, the most powerful thing that a chair can do is the power of convening. And with the firefighter bill that we just heard, you were deeply persistent over the interim of getting everyone together. So thank you, Mr. Chair, for your leadership on that. Senate Bill 326 relates to peer support. And I'm glad we're going in this order. 2 years ago, this committee and this chamber and this body passed legislation that would allow firefighters to receive confidential peer support. And what does that mean? It means exactly what it sounds like. It means firefighters counseling other firefighters in moments of difficulty and grief. And we passed that bill on a bipartisan, unanimous basis. We had to come back the next year to fix a little word in that, but that is now the law of the land because of the leadership of the members of this committee. The bill in front of you, Senate Bill 326, is current law for firefighters applied word for word to our police officers. It allows for confidential peer support for police officers in this state. For those of you who heard about this in Montgomery County, perhaps just about a month ago, there was a police officer who had a mental health issue and required the support of his fellow officers. The reason it made news is because that officer was in the field. They had to close down some of the roads around there while police officers were assisting their fellow police officer and making sure he was safe. That's exactly what this bill is about. It's about officers being able to provide confidential counseling to other officers whose role they understand and whose danger and risk they appreciate. Let me tell you about an important part of the text in this bill that you should be aware of. In the firefighter bill that we've already passed, we provided explicit exceptions where confidentiality would not apply. You cannot use peer counseling to admit to a crime. If you're using peer counseling and someone's health or safety or life is at immediate risk, that peer counselor has the ability to call 911 or bring in emergency services. Those same exceptions are in the legislation before you. So nothing in this bill would allow bad actors to utilize a counseling service to kind of admit to their bad acts, to further their bad acts, or in any way protect them from full accountability that we demand. And so with that, Mr. Chairman, I would just say one more time, this is word for word the same as the firefighter peer counseling bill that we've passed and applies it to our hero police officers. With that, I'd ask for a favorable report.
Good afternoon, Mr. Chairman. Thank you. My name is Dave Rose. I am a almost 38-year veteran of the Baltimore County Police Department. and president of the Baltimore County FOP. I'd like to thank Senator Waldstreicher and Senator McCray for sponsoring this bill. As a member of the Baltimore County Police Department, I've personally witnessed the profound impact that peer support networks have had in helping officers cope with the unique challenges and stressors associated with the job. In May 2018, following the tragic line-of-duty death of Amy Caprio, our department began informal peer support meetings on the second floor of our lodge. These gatherings provided a vital space for officers to come together, grieve, and have mutual support in an incredibly difficult time. Over the next couple of years, we recognize the need for a more formalized structure for the well-being of our officers, and we established regular peer-to-peer meetings, and we have one tonight. They're often attended by our members, peer counselors that you see before you here, and other mental health professionals from across the state and nation. While these meetings have proven invaluable, one concern has consistently been raised by our officers at these meetings is that their confidential communications may not be protected. Many officers are reluctant to speak freely about the personal and professional challenges they face, fearing that their words may be disclosed to management or others without a need to know. The establishment of legal protections for confidential peer support communications as outlined in Senate Bill 326 is essential in addressing the concerns and ensuring that our officers engage in these critical conversations without fear of reprisal or a breach of trust. Currently, firefighters in the state of Maryland are afforded the protection of confidentiality during peer support sessions. Law enforcement, however, do not have these same legal assurances. We are often on the same scenes and witnessing the same trauma. This bill would extend the same level of confidentiality to law enforcement officers, recognizing that we too are often exposed to those incidents. I respectfully urge you to vote in favor of Senate Bill 326. This legislation will help foster a safer and more supportive environment for our officers. Thank you.
Good afternoon. I'm Lieutenant Catherine Greenbeck, and I'm speaking on behalf of Baltimore County FOP Lodge 4. I'm a 23-year veteran of the Baltimore County Police Department, and I currently serve as the commander of our department's behavioral assessment unit. The peer support and wellness team is one of the teams that I oversee. I'm speaking today in strong support of SB 326, which will provide legal confidentiality of communications between police officers and their specially trained law enforcement peers. Situations and demands specific to the field of law enforcement result in unique stressors and often trauma, which cause both acute and cumulative stress reactions. Peer support programs strive to assist police officers who are in active crisis, as well as mitigating the effects of all forms of stress to which police officers are routinely exposed. The mental wellness of our police officers is good for everyone. Dave Rose told you about the FOP-sponsored peer-to-peer meetings that were initiated after the devastating loss of Amy Caprio in 2018. Our department also responded and developed a formal peer support and wellness team, which offers moral and emotional support, peer counseling, and access to programs that focus on officer safety, wellness, resiliency, and all of that on multiple platforms. Confidentiality is a crucial key part of success to any peer support program. In our department, peer support team members are not therapists, and currently Maryland law does not provide privilege for those communications between police officer peers, as some states already do offer. SB 326 will provide the same level of confidentiality that is currently enjoyed by Maryland firefighters, and I respectfully urge you to issue a favorable report for this bill. I want to thank Senators Waldstreicher and McCray for sponsoring this bill and the whole committee for your time and consideration.
Good afternoon, Chairman Smith and honorable members of the Judicial Proceedings Committee. My name is Sergeant John Hadaway, and I'm a 24-year member of the Baltimore County Police Department here on behalf of Baltimore County FOP Lodge 4 and also an Army veteran. I am in charge. I am the peer support and wellness manager for the Baltimore County Police Department, responsible for overseeing health and wellness for our over 2,000 sworn and professional staff members. According to research published in the Journal of Traumatic Stress, law enforcement officers are exposed to an average of 178 critical incidents in a career, whereas an average citizen may experience 3 to 4 in a lifetime. Over the last several years, a majority for this legislature has been on police reform and understanding why officers engage in behaviors that are unprofessional, illegal, and inconsistent with their training. In the majority of those cases, if the stigma had been mitigated and the proper training, resources, and support was given, those officers in the videos may not have gotten to the point where they are now national news. Every day I encounter officers from throughout the agency and other jurisdictions who still express to me they are leery of anything related to mental health, and peer support would be the last group of people they would talk to if they are suffering or in crisis. Without confidentiality, officers withhold a majority of what they are experiencing for fear of the information being leaked to leadership, them being forced to testify in court, even though the discussion is mental health centric and not about tactics, and for fear their families, friends, coworkers, and organizational leaders may be learned that they are struggling. Senate Bill 326 will allow trained and vetted peer support team members across the state of Maryland to more effectively engage those who are in crisis or struggling by reinforcing the confidentiality aspect of peer support. Confidentiality allows fearful officers who may feel shame to come forward and seek help in their darkest moments. I want to thank Senators Wallstreicher and McCray for introducing this legislation and the honorable members of this committee for allowing me to provide my perspective as a peer support manager today. I urge you to send this bill for a vote and make a favorable recommendation. Thank you.
Good afternoon, Chairman Smith, members of the JPR Committee, and distinguished guests. My name is Lieutenant Jessica Murphy, and I am a 26-year veteran of the Wycomico County Sheriff's Office. I'm also a state board member of the Fraternal Order of Police and a co-founder of Behind the Line, Inc., a 501c3 not-for-profit providing wraparound mental health services, including peer support to first responders, the military, and their families. I'm here to testify in support of Senate Bill 326, which provides for confidential peer support services to law enforcement officers. I and many other law enforcement officers, some of them here today, have been working to improve the mental health and wellness of officers for many years. Although I believe we have made some very good improvements, we still have more work to do. According to Blue Help, 712 officers have taken their own lives nationally since 2020. To say we have a problem is an understatement. While the fire service and other states have already provided confidential peer support services to law enforcement officers, the state of Maryland has not. We are not asking for anything more than what others have already been given. I believe providing a favorable report for Senate Bill 326 is a huge step in the right direction for our law enforcement officers. I know police officers experience many critical incidents on a daily basis over a number of years. It is no wonder why they experience psychological trauma and stress at home and at work so frequently. We give them guns for their protection, but we do not give them the necessary tools and resources to protect our minds. Furthermore, for those smaller police agencies like the one that I work at, this will also give them a good opportunity to establish peer support services within their jurisdictions at little to no cost. And the confidentiality piece is very important because it is something that, of course, most officers wouldn't talk to another peer if they thought there was going to be anything repeated. Lastly, peer support has been proven to diffuse stress right after critical incidents and in the long term. For this reason and many more reasons, I ask you to return a favorable report for Senate Bill 326. You will be saving lives by doing so. Thank you very much.
Thank you, Mr. Chair. So I don't know who wants to, well, let me just say what I've got to say here. So I can tell you from my own personal experience that I've been involved in incidents from the military and police work where my coworkers have been shot and I'm the first, get there to respond to them and put them on a, you tend to them and you put them on a helicopter and you think you're not going to see them again. And the first thing they want to do is they want to interview you.
Yes.
Yep. And then, and so when, it's a very frustrating thing because the only thing I'm worried about is my coworkers, right? And I can remember very vividly having this discussion with them about that they were like, well, you can just talk to us. You need to come talk to us. They literally, because my car was in the scene, they locked me in and to another cruiser and took me back to headquarters. They're like, you need to talk to us. I'm like, I don't want to talk to you. I have nothing to say to you. Because in that moment, we're all human. And in that moment, I was like, they were like, nothing you say is going to be used in any administrative hearing. I'm like, that's bullcrap, and you know it, because it can be used currently, can it not?
It can, yes.
And my concern is that as a police officer that just responded and put two of his friends, one who was shot right above his vest in the throat, the only thing I wanted to do was go see him. And they have a pattern of wanting to lock you in and talk to you. They got to get that statement right then and there. And I had zero protections. And the only thing I was worried about is that I was going to say something that would get me administratively brought up on charges because of what I thought about that suspect that was also shot. Is that a real concern as a police officer, that if I, as a responding officer that gets there and tends to my coworkers and has to also give aid to the assailant by law, but I have a certain feeling about that person. If I express that feeling in today's climate, and it's documented under this bill, because I don't particularly care for that person that just shot my friends, could I be charged as a police officer?
Kind of loaded. I mean,
in an administrative hearing, could I be brought up on an administrative hearing for expressing my personal opinion of frustration in that moment and the emotions that are around that? Could they, in current environment, say, this is conduct unbecoming, and now we want to remove you and we're going to put you in and we're going to charge you?
Because you've made statements under stress.
Correct.
And while those statements might be something that 72 hours later you would never have made after you came down, yes, they would be used against you and they wouldn't be confidential.
So and they wouldn't be confidential.
Correct.
So that's my point. So I chose, Mr. Chairman, others, my choice was to shut down and get out of the meeting and leave. I just wanted to get home and see my wife and kids. I wanted to hug them. I wanted to get out of the uniform. I wanted to go check on my friends. So now what I'll tell you is they're like, this is the CISM, the crisis intervention, stress management thing. But it's not safe to this day for an officer to go in there and deal with these particular incidents and be able to debrief in a safe environment to allow those to get the appropriate avenues of services to them if needed.
I've responded to probably close to 80 incidents where an officer was involved in an incident where either they directly attributed to the injury or death of someone or one of the partners were. And ever since I can remember, somebody from the peer support unit comes out to the scene and has their information, their brochures with them, and offer their services to listen, be a sounding board. And not once in any of those circumstances I've been on has anyone taken advantage of it, because if they spoke to the peer support counselor, the counselor could be brought in and said, what did that person tell you?
Correct.
And it's not confidential. And even though you're talking about how it affected you personally, it would not be confidential.
And that's my point. And I appreciate you all coming out here on this bill. It's a very important thing. And in a time when we're hemorrhaging law enforcement because of the villainization of the occupation over the past few years, this is an important step to try to at least protect their minds from all these incidents, because I know we all go to a lot of terrible incidents, unfortunately.
Officers across the state have reached out to me since we got this bill introduced by the senator, and all I've gotten is, thank God it's about time we had something like this. I can't believe it's taken this long to have something.
Yeah, I mean, I think the time and proximity element to this is really important, because immediately right after, when you've got your coworkers' injuries still upon your own being, you don't want to keep talking about it.
I've been involved in directly two critical incidents. And I can tell you that it took a couple days to feel it come down.
Right. And as a part of this, I will tell you that the agency I was a part of did a really great job of the next day, because we all came back into work and they were like, no, not today. So there's ways to adjust that. I thought that was a really good outcome, that they recognized in this environment that it wasn't time to come back to work yet. But at the same time, I thought that because this bill does not provide that confidentiality for those officers to be able to freely express that. So I appreciate y'all bringing the bill out. I think it's really important, so thank you.
Thank you.
Further questions from the committee? Excellent. Well, Senator, thank you for that reflection. I mean, in the background, we had an exchange yesterday where there was, an inquiry about someone's kids or something in their family. And one thing I just remind folks that come to testify and also here is that you never know who you're talking to. Everyone's got lived experiences that you don't know, that may not be, apparent when you look at someone, the way they dress, the way they walk, the way they talk. Everyone's got different backgrounds and experiences, and so when you come here, it's to show some vulnerability and share those things to make policy better in this open forum. It takes a lot of courage. So I want to just thank folks that are willing to step out there and do that, and thank you all for your testimony. So thank you all. I know we've got 2 more witnesses left on the bill, so sir, come
Senator,
on up.
yes, sir. Committee, thank you. My name is Steve Thomas. I'm a lieutenant with the Anne Arundel County Police. I'm the peer support coordinator and our CIT coordinator. I always say I probably have the worst job in the world, because either myself or my unit responds to every traumatic incident that happens. I have the worst job in the world, but I love it because we get to help people when they're the most vulnerable and need help the most. We and I'll say peace officers is how I define myself. I am one of the officers. I grew up in my community, where I still live in the community I grew up in. I work in that community. I patrolled it as a patrolman. And the key to community policing is taking care of police officers. I was at our academy today teaching our new supervisors about how to help the communities that we serve. And the key question, what the chairman said earlier, is we all have our lived experience. We have to stop asking the community, what's wrong with you, but what have you experienced? But don't we have to do that for the officers that are there serving the community? Don't we need to take care of the officers the same way we expect the officers to take care of the community? We all want police reform, and that's the key. When we recognize that officers are hurting after traumatic incidents. And I've been on a lot of severe incidents. Today, my team is in Washington, D.C. I got a call first thing this morning from the Command of Natural Resources Police saying, can you please send a team to help our divers who are recovering bodies? While they were en route, I got a call from the state police mental health unit saying, your team's there, can they help our troopers? Because we know the effects trauma has on our bodies, on our minds, and we carry that with us. And it's not just work-related, it's our family trauma that we have. All I ask is that we start treating our officers the way that we expect them to treat the community, and that is what truly police reform should be. And part of that is, last year I was before this committee on training, and to implement the training, we have to be able to have that freedom to be able to help people as they need it. Thank you.
Good afternoon. I'm Dr. George Everly. I am a clinical psychologist, a public health researcher, and a neuroscientist. And in the late 1980s, my colleagues and I founded this field of law enforcement peer support. I literally wrote the book on the subject. I can stand before you and say that this is not just a process of communication. This is a process of saving lives. It's a process of saving marriages. It's a process of saving careers. Why do I say such things? because we know that there is a premature death effect in law enforcement. Said simply, that if someone goes into the law enforcement profession, they are expected to have 10 to 20 years less life expectancy than their cohort than the general population. We have been able to do something about that, however. In 2004, the FBI Law Enforcement Bulletin, which was published out of the Behavioral Sciences Unit at the FBI, urged us to develop peer support programs. We had already laid that foundation several years earlier. The key to peer support programs, however, is communication. Part of that is disclosure. The process of disclosure in and of itself, and I can tell you as a neuroscientist, is inherently healing. Science tells us the single best predictor of human resilience is human support, the support of other people. But that support is predicated on something very precious, and that's called trust. Without that trust, there will be no disclosure, there will be no perceived support. Confidentiality is an essential element to the peer support process. Without it, people will tend not to use it, as you've already heard. People go into law enforcement and we train them to be suspicious, and they do that very well. But the problem is it extends into their personal lives. And as you've already heard, without that trust, without that belief that this is a confidential, safe space, we will not have anything called peer support. And we will continue to see marriages end, careers end, and sadly, lives end. I urge you to vote favorably for this bill. Thank you very much.
Questions for the committee? All right, thank you all very much. We have one last witness signed up favorable with amendments. Ms. Sample.
Thank you to the chair and members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support with amendment Senate Bill 326. I agree with everything that the panel before said. The only thing that we're asking for is that you include correctional officers in this as well. They experience increased amount of trauma in our facilities right now, particularly because of the mental health transfer backlog. So they're seeing increased assault. The stress is immense in these jobs. And, I would add that the life expectancy of corrections officers is actually almost 20 years less than the average. So we just would like to see them included in this as well. We think they could really benefit. It will help with staffing and retention. And so we would support with amendments to include correctional officers. Thank you.
Thank you very much. Questions from the committee? All right, seeing none, thank you. With that, that'll end the hearing for Senate Bill 326. We'll now move on to Senate Bill 298. Senator Waltz-Rager.
Thank you, Mr. Chairman. Excuse me. My last bill for today. I know we have some other bills coming. Thank you to the Attorney General's office for bringing me this legislation. We touched a little bit on hearsay on Senator Love's bill. I stepped out of the room, unfortunately, for another commitment during that bill. So if I'm repeating concepts that were exposed under Senator Love's bill, I apologize. As you know, Mr. Chairman, members of the committee, under current law, children are provided a hearsay exception as long as certain reliability indicia are found by the court. But we don't allow an exception for vulnerable adults. By vulnerable adults, I mean people who are elderly and often victims of elder crime, especially in our nursing homes, but not exclusively people who are elderly or have other disabilities of age like Alzheimer's. Vulnerable adults also includes people who might not be elderly, but otherwise have intellectual disabilities that make it difficult for them to communicate or testify in court. And so what Senate Bill 298 does is it takes section 11301, which is the child hearsay exception, and applies it to our existing definition of vulnerable adults. Like section 11301, it then applies a procedure by which the reliability of that witness can be attained out of court and maintain the constitutional requirements of the Confrontation Clause. So the bill in front of you mimics that current law. We are comfortable with its constitutionality. It comports with State versus Snowden, which you'll hear a little bit more from the Office of the Attorney General, and we believe is the appropriate policy to protect vulnerable adults in Maryland. You're about to hear from the Office of the Attorney General with specific examples of when this may be applicable, and the likelihood that people are getting off for very terrible crimes, especially for crimes against elderly folks in nursing homes, is exactly why we need this bill. With that, Mr. Chairman, I'd ask for a favorable report on Senate Bill 298.
Good afternoon, Mr. Chairman and distinguished members of the committee. My name is Zach Shirley, and I'm the Director of the Medicaid Fraud and Vulnerable Victims Unit in the Office of the Attorney General. Vulnerable adults are often targeted by abusers, scammers, and sexual predators due to their disabilities, mental decline, and physical frailty. I'm before you today to ask you to give the power back to these victims and to ensure that they can participate in the justice process as fully as anyone else. The rule against hearsay has been a cornerstone of our legal system for well over 250 years, and there's not an attorney out there who can't quote from memory an out-of-court statement offered to prove the truth of the matter asserted. But in those 250 years, we've come to realize that in some cases, allowing hearsay evidence to be considered is not just appropriate, but essential to justice. Vulnerable victims' cases are those cases. Due to the nature of vulnerable victims, it's common to see memory loss, dementia, worsening mental disability, and developmental issues that hinder communication. As a result, at the time of trial, many of the victims in our cases cannot testify in the traditional manner or do not remember the events at issue. Senate Bill 298 would allow a vulnerable victim's prior statements to a trusted individual, made at a time when they did remember, to be part of the evidence at trial and would empower them to confront their abusers while assisting our office in obtaining justice. But Senate Bill 298 is not a one-way street. It is also structured to protect the defendant's due process rights. There will still be an opportunity to confront the accuser, and the court will have to determine that any statement offered meets a standard of trustworthiness before it's admitted. In fact, this bill is modeled on an existing Maryland law that provides a similar exception for child victims of abuse and certain other crimes. That law, Criminal Procedure 11304, has already been tested by the crucible of the courts and is today a well-established exception. I was going to share with you the story of Grace, who was an 84-year-old wheelchair-bound resident. Would it be okay? She's why I'm here. A few more minutes?
If you just want to wrap it into a conclusion.
Okay. Grace, sorry. I'll be brief. Grace's hand was maimed by a medical technician while she was a 84-year-old wheelchair-bound patient in a rest home. And she made a statement on body-worn camera when the police came to investigate, and we investigated that case, and we had that statement, and the perpetrator was indicted. But ultimately, she died before we got to trial. And because all we had was that video, and that video was hearsay, we weren't able to do anything. And I would just say that had this bill been in place, we would have gotten justice, and we would have gotten that provider out of the system so that she couldn't victimize anyone else. I urge a favorable report on Senate Bill 298. Thank you.
Good afternoon to the chairman and the committee. Thank you for this opportunity to testify in favor of this bill. Thank you to our sponsor. This bill also will help criminal prosecutors at many of our local jurisdictions. I am Sherry Green, the Division Chief of Economic Crimes and the Older and Disabled Persons Unit for Baltimore City State's Attorney's Office. As an Assistant State's Attorney for Baltimore City specializing in elder abuse law, I strongly urge the committee to pass this crucial legislation addressing a critical gap in our current legal framework that often leaves our most vulnerable citizens, our older adults, and those unable to provide for their daily needs without a voice in the criminal justice system. It creates a situation in which our older adults, disabled persons, and those with cognitive disability are not given as free an access to justice, and the pathway to justice has many roadblocks and deterrents. They are persons who were born and raised, many citizens aged 68 and older are very valuable treasures in our community. They have been actively participating in engaging in commerce, working, raising families, and now they've reached their golden years. But we have to keep in mind that some of their background is different than, and their experiences are different than you and I. For example, they may have been born and raised and worked in a time when, long before computer scams had appeared on the horizon, long before extended families were separated by cross-country movement. Now we have families who are living in out of state, and many of our seniors are isolated and are not able to get support and fall victim to fraudsters and those who target them because they do not expect they will be capable and able to testify by the time the case gets to trial. These out-of-court statements will greatly assist us in pursuing justice for these victims. Thank you.
Excellent. All right, thank you very much. Questions from the committee? Senator Henson.
Thank you, Mr. Chairman, and thank you to the bill sponsor. I'm trying to reconcile, it seems like the person or the target of this would be someone who's a vulnerable adult, but it also stands to reason that a vulnerable adult is perhaps more unreliable than the average witness because of perhaps the conditions that make them not suitable to come into court to testify, or perhaps conditions that if they are at home or in another place in the care of someone make them more subject to influence, intimidation, manipulation, cognitive decline, all the different things. How could we ensure I know there's measures in here to ensure the validity of the statement, but I want to feel as comfortable as you do about that these statements will be accurate and they won't be the result of all those other things.
Thank you, Senator. And I think your concerns are well placed. And the procedure that we have laid out is one where before the statement ever sees a courtroom, it will be addressed by the court. And the court's going to look at it, and we sort of enumerate a number of considerations that the court will make in its analysis as to whether or not this declarant is trustworthy, whether or not the situation lends itself to making the statement reliable. And so certainly there's the possibility that we have an unreliable narrator if we have a vulnerable victim, but that should be assessed at the front end of this process. And if it's determined that our vulnerable victim does not remember properly or cannot, or that at the time the statement was made that perhaps it wasn't reliable, then it would never see the inside of a courtroom.
The judiciary has, thank you for your response. The judiciary has opposition in testimony in, and what their issue is, or one of the issues they identified, is the use of the term shall and not may, that this would trigger requiring having that sort of hearing to determine if the statement could be used. Do you have an opinion on altering that language?
Yeah, I think I'm open to that discussion. I'm deeply sensitive to what the judiciary has said here, and we have limited judicial resources. Having this hearing each and every time would be a challenge, I imagine, for the court. I think it's a challenge that they could meet, and I think this change is worth the spending of those precious judicial resources. Nonetheless, I'm deeply empathetic with what they've said in their concern about the bill and open to going to a may in order to address those concerns.
Okay. And then my final question, making sure, I want to make sure it doesn't turn into a battle of the expert witnesses, where one person says this person is no cognitive decline, their testimony is 100% reliable, and then the other expert witness says the other thing. In my mind, when we get to that place, one of the real problems with that is that it becomes a power imbalance. It's a dynamic of resources. Mm-hmm. If you have the resources to be able to marshal experts who will see it your way and to present compelling testimony, then oftentimes the person with the most resources wins. How will we make sure that this doesn't become that?
Yeah, I think that's a good question. I'm going to defer to the Attorney General.
So I would say that if you look in Section 3, where we're talking about what the court is going to look at during that initial review to determine whether or not that this statement is admissible, this isn't something that we're going to bring in expert testimony on. We're going to be looking at the context of the statement. Who made the statement, where, when, to who? Right? What was the situation? Does that tell us that this is likely reliable? But I don't think that you're going to see expert testimony coming in because that's not really part of what the court's considering at that point. Later on down the road, if they try to undermine the witness's mental state at the time, that might happen during trial. But during this preliminary stage, what the court is instructed by this bill to examine doesn't include anything like expert testimony.
That perhaps is more troubling than the perhaps abuse of resources if we don't have any sort of kind of measures about if vulnerable adults are the targeted population by this legislation and there's no sort of initial screening of someone's cognitive abilities, do you feel like we are missing an opportunity with this to, my concern, and I think I expressed it at the front end, is that people who are vulnerable adults, it comes with a number of challenges that are already baked in. And what I don't want is to create this loophole where the defendant in a case doesn't get that opportunity to fully flesh out if the person as a witness is reliable. And if we don't have any sort of understanding of that on the front end when we're deciding to bring these statements in, at what point does that happen and how is that not overly prejudicial to the defendant?
Sure, and I don't want to put words in your mouth, but it sounds like part of your concern is the right to confront the witness and sort of pressure test their reliability. Is that?
That's right.
Right, and so that will happen during this pretrial procedure. The defense will have the opportunity to cross-examine the witness. We have to do that. The Constitution requires it, and under Crawford, right? So we want to do this pretrial hearing early while everything is still fresh in everyone's mind because we want to preserve that statement. And one of the ways we do that is by allowing confrontation to happen, which is to say the defense attorney gets an opportunity to cross-examine the witness, to pressure test their testimony, to see if it's reliable, to try to point out flaws in testimony. That confrontation that's required by the Constitution still happens. It just happens earlier in the process to try to preserve the statement in case we see further decline as the case proceeds.
So witnesses here for this hearing, you can ask all those questions on cross-examination about your medical history and whatever they need to put out there to gain information on to figure out if this person is reliable in terms of cognitively.
Correct.
Okay, I understand that. Thank you. Thank you, Mr. Chairman.
Good afternoon, Chair, Vice Chair, and committee members. My name is Catherine Gravely, and I'm an attorney for violence prevention at the Center for Hope. I'm here today in support of this bill. With this bill, Maryland has the opportunity to join a number of other states, including Indiana, Minnesota, and Vermont, in supporting the testimony of two different vulnerable groups when they've been a victim or a witness to certain crimes: adults of any age that cannot care for themselves due to a mental or physical condition, or two, adults that are 68 or older. These statements tend to be offered by way of video recording and are imperative when a case relies on the testimony of those whose live in-court testimony may be hindered by physical or cognitive conditions. This bill should sound familiar as it directly mirrors Maryland's tender years exception to the hearsay rule in Criminal Procedure 11304, which applies to children under the age of 13. I think it is important to acknowledge that these individuals share a lot of the same vulnerabilities as children under the age of 13 might. Be it that they may struggle to communicate and get help, they may not be in a position to protect themselves, or they simply may not be believed. As a former special victims prosecutor, I could give you a number of examples of cases that haven't been able to be fully prosecuted because the case's viability relied on the in-court testimony of the vulnerable adult alone. In one frustrating case, police took a victim statement by way of having her forensically interviewed shortly after the offense occurred. Fast forward 18 months to the week before trial, and the victim's dementia had advanced so far in that time that she no longer could have a normal conversation, let alone testify or face cross-examination. Without her ability to testify live about what happened to her, we couldn't prove our case because her previous statement was inadmissible hearsay. In a case like this bill allows judges and jurors to see and hear vulnerable adult statements before there are any further changes to their cognitive functioning. It is time for Maryland to extend the hearsay exception already prescribed in Criminal Procedure 11304 to vulnerable adults. For these reasons, we ask for a favorable report from the committee. Thank you.
I believe that rounds out the panel for the proponents of the bill. We have one person signed up in opposition, Ms. Taylor. Anita Taylor.
Hi, it's me. Good afternoon, everyone. Glad to see you. I believe that we have testimony in opposition requesting an unfavorable report submitted by the ACLU and the Public Defender's Office together. I am Benita Taylor from the Public Defender's Office. I have represented children, parents, guardians, and caregivers in child abuse and neglect cases for 30 years. In fact, looking at this statute, I realized that in 1 year, I'm going to be considered a vulnerable adult. I'll be 68 years old. And that, I say, is because there's one thing that we need to think about. I believe that this bill does violate the due process rights of our seniors as well as our disabled adults. It assumes that because I'll be 68 years old, I may be a vulnerable adult. It also assumes that because someone may suffer from a disability, that they are a vulnerable adult. That smacks of ableism and ageism. This bill conflates the child testimony bill, what we call the tender years bill, with adults. People with intellectual disabilities, traumatic brain injuries, and developmental disabilities require different modification or ways of communication to understand and accurately respond to questions. This bill allows the statements from anybody. Unlike the protections in the tender years exception, these statements have to be given to certain individuals, people who have the necessary education and expertise to be able to take a statement from someone who is considered a vulnerable adult and recognize if the question is being asked properly, if the statement is a statement that's being made because they have had it repetition after repetition or whatever. But that safeguard is not in this bill, that these statements have to be given to a particular person. These statements could be given to anyone, anyone. In addition, I would tell you to look at our testimony and review the fact that it is also not just enumerated crimes. It is a laundry list of crimes which include misdemeanors as well as felonies. And as we know, misdemeanors are heard by a judge, the same judge who will be hearing the case. By all of the elements listed, that judge in a misdemeanor will be making the decision of the case already when they do this hearing that is required by the court. My only final note in closing would be that also the other protection is that the right to have a deposition in a child tender years case does not exist in this statute.
Excellent, thank you. All right, questions from the committee? Seeing none, thank you very much. Thank you.
Thank you.
That'll conclude the hearing for Senate Bill 298. We'll now move on to Senator Sidnor with Senate Bill 343.
All right, good afternoon, everyone. Senator, it's just left out, all right. Senate Bill 343 picks up and expands on Chapter 141 of the 2022 session by reconstituting the task force to study transparency standards for state's attorneys and codifying the state's attorney's office case automation system enhancement grant program. Now, what some of you may know, this bill sounds familiar because we brought it back last year, unfortunately. because of the budget situation, we had to wait to hear from B&T, and by the time that money was set aside for this grant program, it was too late to then move legislation and get it through the entire legislative process. However, what we were able to do in working with the Budget and Taxation Committee, we had money that was earmarked for this grant program. And in fact, the grant program is up and running with a NOFA right now that I can tell you has had a number of state's attorneys' offices apply for the grant money that was set aside in last year's budget. So what's the point of this particular legislation? Because we were unable to pass the legislation, the task force that was looking at this particular issue and working actually it expired. So this legislation will do two things. One, it will, like I said, reconstitute the task force so that we can continue the work that we were doing to bring about transparency with regards to our state's attorney's data. But what it also will do is take a program that we funded last year through the budget and actually ensure that it's codified in state law so that we can bring about the type of resources that our state's attorney's offices need and deserve to capture data, relevant data, that we can all consume at some point in the future so that we understand what's going on within our criminal justice system. Over the years, we've taken looks at police officers. We've taken looks at transparency with judges. This is the actual next step is trying to bring forth some transparency with regards to the data that's collected by our state's attorneys and really understanding what's happening when it comes to charges and prosecutions. So with that, again, I would ask that I would respectfully request a favorable report on Senate Bill 343. So that's it.
Good afternoon. Heather Warnken. I serve as Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law. In 2023, I was appointed by Governor Moore to serve on the task force to study transparency standards for states' attorneys, and I'm grateful to be here today to have the opportunity to testify in strong support of this bill. So prosecutors are widely understood to be among the most powerful actors in the criminal justice system. They wield tremendous authority and discretion, deciding what cases to indict, what plea offers to make, and numerous other decision points impacting the lives of not just people accused of crimes, but their loved ones, victims of crime and their families, and society writ large. Now, there's been a groundswell of energy and investment in the need for data-driven systemic reforms across the country in the past decade. I've submitted more extensive written testimony speaking to this, but I'd like to underscore just a couple of reasons why this bill is so important for Maryland, directly informed by my experience on the task force. So first, advancing both the infrastructure and the culture change that we need for quality, consistent data collection at the county and state level is a long road. And in our state, this work has just begun. SB 343 provides the resources needed and extends the life of the task force to examine the issues and implementation questions and help steward a path forward toward greater equity, systemic legitimacy, and research-backed change. This bill also expands and diversifies the task force membership to include needed perspectives, including the Office of the Public Defender. So it was my experience in the task force meetings previously that this omission impeded our work. A cadre of diverse Maryland counties and elected states attorneys are already leading the way in moving us from anecdote to evidence, pursuing data collection and transparency, and uplifting why it matters, including addressing the racial disparities in case processing that contribute to Maryland's status as first in the nation in over-incarceration of Black males and supporting allocation of limited resources in effective, efficient ways. So we urge a favorable report. Thank you. Another panelist is a virtual.
Yes, good afternoon, Mr. Chair and Senators. Thank you for the opportunity to speak in support of SB 343. My name is Melba Pearson, and I serve as the Director of Prosecution Projects at Florida International University, and I am one of the co-managers of the Prosecutorial Performance Indicators, also known as the PPIs. Before this role, I spent 16 years as a homicide prosecutor, giving me firsthand insight into the complexities of our justice system. At the PPIs, we partner with prosecutors' offices across the country, using their case management systems to develop public-facing dashboards that allow communities to see and understand how justice is being administered. Since 2017, we have worked with over 40 prosecutors' offices nationwide. In Maryland, we have launched a dashboard in Montgomery County in 2023, Frederick County in 2024, and this year we will be launching in Baltimore City. Data collection is not just about numbers, it's about accountability and informed decision-making. Questions around juvenile involvement in violent crime, offense types, age ranges, case processing times, recidivism rates can all be answered through comprehensive data analysis. Data allows prosecutors to track trends, assess policies, and implement solutions that work. Without it, we are making decisions in the dark. SB 343 is critical because it provides much needed financial resources to prosecutors' offices to enhance their data collection efforts. We cannot expect offices, especially those who are already stretched thin due to staffing shortages, to take on additional transparency measures without proper funding. Unfunded mandates do not work. If we truly value justice, we must invest in the infrastructure that supports it. At the PPIs, we have worked closely with the University of Maryland, Bowie State University, and Morgan State to engage the community. Through listening sessions, one thing is clear: Maryland residents want greater transparency from their prosecutors. By expanding and reconstituting the task force to include more diverse voices, SB 343 will help establish balanced, measurable, and attainable metrics that will reflect the needs of Maryland residents. At its core, justice must be transparent. And with that, I urge a favorable report for SB 343. Thank you.
Thank you very much. Any questions or comments? Okay. Steve Pro. Yep. All right. Thank you. We have one opponent, Steve Pro. My best buddy.
Good to see you, Mr. Chairman. Good to see you in that position. Smiling. Good afternoon, committee. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases for over 40 years. In opposition to Senate Bill 343, we asked for an unfavorable report. I don't know if this committee's seen the fiscal note. It just came out, but the fiscal note indicates a lot of money that we could spend more time with, given better places to put that kind of money. It's a big, big fiscal note that I saw this morning. I gave Senator Sidnor a list of all of the prosecuting offices, and there are basically 24 different systems, same vendor, different systems that Senator Sidnor got in December of last year. To tie those systems together, sadly, will take a lot more money than what's given in the fiscal note. Sadly, it is something that should have been done in 2011 when Senator Sidnor knows I asked for a unified process, but now each jurisdiction has a separate system in order to get their data from. My problem with the bill is several. First of all, there is no united system. Second is several counties don't even own their system. The county does at that time. Third of which, I'm asking Senator Sidnor, please do not put agenda-driven philanthropic-sponsored groups or academics on this committee who truly do not understand the victims here in Maryland. They never prosecuted a case here in Maryland. They don't understand what drives Maryland and why Maryland is different. Second, please remove the Public Defender's Office, page 5, number 11. The Public Defender's Office would not allow us to be on their board. And I said to Senator Smith last year, Senator Muse, putting the public defenders on this committee is like watching the bear. And now I'm saying it's like watching, I'm sorry, I'm smiling at this because watching the pit on Max. And I apologize because if you ever seen it, it's like a mess. Putting the public defenders on is a total mess. And Senator McKay, the Public Defender's Office can't do it. You know why? They're too busy. They're too busy to see you. They're too busy to do everything. They don't have time to be on this committee. The Public Defender's Office should not be on this committee. And I'm going to get done just like everybody else does because I was smiling at the pit from there. Second is it's anti-victim. Imagine, Senator Sidner, me telling a victim, I'm sorry, I can't talk to you, victim. I got to get your age, your sex, and everything about you before I talk to you, which is what this bill would require. It can't be. I can't go to a victim and say, slow down, let me write down the plea offer between me and the Public Defender's Office because Senator Sidnor wants me to do it. The legislator wants me to do it. It would interfere with the relationship between prosecutors and victims. It is anti-victim, the bill. The Public Defender's Office doesn't belong on it. Victims' rights are infringed. And watch the pit, and you'll see what a mess it is to put the Public Defender's Office in. And I'm smiling when I say it. Senator Muse, I apologize for my brief delay in that. But I'm happy to answer any questions.
I'm sitting here a little bit puzzled because I wonder what Billy's testifying about. Again, this is a reconstitution of a task force that was constituted a number of years ago. Did the sky fall under that task force that was constituted?
It was unfair. You asked for balance. Balance, it's unfair to put the Public Defender's Office
Also
on.
was the task force that was
Everyone on there was
constituted.
what? A philanthropic representative who did not represent anybody in the state's attorney's interest other than myself. and
How
Mr.
was it
Gibson.
unfair?
It was 16 against 1.
It was 16 against 1?
On that committee, who voted, and everything you brought up and every vote you brought up, who voted with the state's attorneys? No one.
That's not accurate.
Remind me of who did vote on what bill.
I'm not going to go there.
Remind me, please.
I'm not going to go there. But I think what you're doing is certainly disingenuous.
To ask for the Public Defender's Office to be removed.
That's not what I'm talking about, Mr. Kroll.
To ask that victims be heard.
That's not what I'm talking about, Mr. Kroll.
That's what the bill says we have to do, Senator.
The victim, there is a victims' right organization on this and within this task force. So I'm not understanding how it's anti-victim.
It's anti-victim that before we talk about a plea agreement, I got to ask their age, their gender, and their date of birth.
This is a bill that creates a grant program for the state's attorney's office, correct?
Part of the bill says that. Part of the bill says that.
I'll get there. Am I correct?
Part of the bill does say that. I told you that.
It does say that. All right. And then the other portion of the bill reconstitute a task force that had already existed before, correct?
And what did they accomplish, Senator?
What did they accomplish? There's a report that shows what they accomplished, and what we found out was that there were a number of state's attorney's offices that didn't have case management systems.
And I showed you that. I told you that beforehand. I told you I asked for a unified one. I said that to you. I said we needed it in 2011, and it wasn't done. I showed you the statistics. I want the balance that you talked about the last 2 days. I want the balance between prosecutors and people who are aggrieved. And this is not balance. This is not balanced.
I'm going to leave it there.
All right. All right. Thank you very much. Further questions for the state's attorney?
Thank you.
Excellent. Thank you. All right, so that will end the hearing for Senate Bill 343. We'll now move on to Senate Bill 291.
Senator Stater testifying on Senate Bill 291. Good afternoon, Chair Smith and colleagues. Senate Bill 291, the Maryland Second Look Act, seeks to address Maryland's racial disparities and advance public safety by allowing people who have served at least 20 years the opportunity to petition the court to modify or reduce their sentence based on their demonstrated rehabilitation. This bill requires the court to consider a number of factors, including the nature of the offense and any statement offered by the victim or the victim's representative. Victims will have full agency and autonomy on whether or not they want to participate in this process. For some, it is a part of their healing process. And I want to make certain that I'm saying that for some, it is a part of that healing process. Not everyone just wants people to be thrown away and forgotten about or feel re-victimized. For some people, it is a part of that process. Additionally, the bill requires that the court finds that an individual would not pose a danger to the public and that it is in the interest of justice to modify the sentence. The Maryland Second Look Act seeks to ensure that decades later, sentences can be reviewed and based on our current understanding of fairness and racial justice. It represents a commitment to redemption by offering an opportunity for individuals who have demonstrated growth and rehabilitation and responds to the critical needs for judicial oversight and presents a cost savings measure for Maryland amidst our $3 billion budget shortfall. With regards to redemption, there is a large body of research demonstrating that the likelihood of committing violent crimes, including murder, declines significantly with age. Maryland-specific data supports these findings, showing that individuals convicted of violent offenses are among the least likely to reoffend. The Maryland Second Look Act embodies the principle that sentencing should not only hold individuals accountable, but also provide a pathway to redemption. The Maryland Second Look Act acknowledges the inherent capacity for change and for personal growth, emphasizing rehabilitation as a fundamental pillar of justice. Currently, Maryland offers no legal avenue for individuals serving extended sentences to petition for sentence modifications based on demonstrated rehabilitation. By introducing this opportunity, Maryland affirms its commitment to a justice system that values accountability, the potential for reform, and fairness. This is not a get-out-of-jail-free card. Incarcerated individuals still must prove to a judge that they have changed and deserve a second look. The Maryland Second Look Act also addresses the critical need for judicial oversight. The 2004 change to Maryland Rule 4-345 that restricted courts' revisory power over sentences to a 5-year window has left Maryland without a viable mechanism to address decades-long sentences. This limitation disproportionately affects individuals serving decades-long terms, as judges are often reluctant to reconsider sentences early in their duration. In the immediate aftermath of a serious offense, emotions run high, making it challenging for sentencing judges to accurately gauge an individual's potential for change. However, with the passage of time, a judge can better evaluate a person's growth, progress, rehabilitation based on their demonstrated track record while incarcerated. Finally, Maryland spends over $59,000 annually per incarcerated individual, with costs rising significantly for aging prisoners. Due to increased healthcare needs, by creating a pathway for sentence reconsideration for those who pose little to no public safety risk, the Maryland Second Look Act allows the state to reallocate funds towards initiatives that enhance public safety, such as reentry programs and mental health services. For example, for over 200 individuals released under the Unger decision, the state had a projected savings of $185 million. This included the cost for reentry support services provided to them. This measure can ease prison overcrowding and reduce the burden on taxpayers. In the 12 years since the Maryland Supreme Court ruled in Unger versus Maryland, the improper jury instructions invalidated with the life with parole sentences of 235 individuals, and overwhelmingly 96% have successfully remained in the community without incident. 96%. The Maryland Second Look Act is grounded in evidence, compassion, and fiscal responsibility. It provides individuals with the opportunity to prove their rehabilitation and contribute
positively to their families and their communities, all while maintaining a strong commitment to public safety. It will make our judicial system fair and save the state money in the process at a critical economic moment. For these reasons, I urge this committee to give this bill a favorable report. Thank you.
Good afternoon, Chairman Smith and other members of the committee. I am Olinda Moyd, and I'm here to testify in support of this bill as the director of a law school clinic that represents individuals under the Juvenile Restoration Act and as a practitioner who has witnessed firsthand what second chances look like. Excessive sentences that have been doled out decades ago have resulted in people being kept in prison far beyond the point of being rehabilitated and long after they have healed from the trauma that sent them to prison in the first place. The Juvenile Restoration Act is premised on the concept that young people are less culpable than adults and that they are redeemable. I believe that that redemptive quality is not limited to people under 18 years of age. This legislation mirrors the Juvenile Restoration Act in that it allows for people to be released or to be considered for release after 20 years, and they can petition the court. Once the court deems that they are eligible, then the court must hold a hearing where the judge reviews a list of factors to determine whether or not the person, one, poses a danger to the community, and two, whether it's in the best interest of justice to reduce their sentence. Through this process of review, it balances public safety with rehabilitation by examining things like the nature of the offense, the institutional progress, the individual's fitness to re-enter society, as well as the statements from the victim. The bill merely creates an opportunity for review. It does not guarantee release. You will hear now from an individual who is a victim who also believes in second chances. Thank you.
Good afternoon, Chairman Smith and Honorable Committee. Hi, my name is Dr. Deborah Haskins, and I am a victim and surviving 2 homicides. Our son Joseph in Baltimore City in 2013, a new dad, and our nephew Reuben in Baltimore County in 2014. 2 innocent victims. Their murders led to my husband's health crisis and death in 2016. I also have family and friends who experienced incarceration and had second chances. But I'm here today to share why it is important for me as a victim to support the Second Act bill. First, not all victims are the same. We are not monoliths. Everyone's victim experience is their experience, their journey, and each person, each family will choose a path for healing. What we're left with is how am I going to make sense out of this horrendous experience. And what I know personally, which is also influenced by my faith in God and by my profession as a therapist and as a human being, is this. I decided that for me, not to pass on generational trauma. I have to heal. Part of my healing includes forgiveness. And forgiveness is not an overnight process. I'm forgiving every day of my life. But what I also know is this. Many justice-involved individuals were born into conditions, families, and communities that did not provide them the best due to disparities like poverty and racism. Many are trauma survivors like me, and they had no resources early enough to help them intervene a chronic condition. I know that God desires each of us to experience wholeness, and while prison is not the place for healing, it can happen in even that horrible space. And so I'm hoping that passing this bill will offer justice-involved humans opportunities to demonstrate in 20 years if they work on themselves, if they can restore themselves to become a better human being, then Maryland can give them a second chance. Please vote favorable for SB 291 and think of your second chances. Thank you.
Excellent. Thank you very much. Question from Senator Muse.
Yes, first of all, if I may, I want to thank you. We grew up together, and in fact, her husband, who was in heaven, was my roommate in seminary. We did wreak havoc, even though it was a seminary. And we were in each other's wedding, and we were ordained together, and he was a great preacher. I'm proud of the work that you're doing. I'm proud to see that forgiveness is possible even in a situation like that. I heard a tremendous testimony in Black Caucus this morning from a young man who went to jail when he was 15, served 29 years. 29 years. And would you all agree that this is not a get out of jail free card, right? This is, Senator, it's not a get out of, because some would say, oh, it's get out of jail free card.
No, it's the title. It's a second look.
It's a second look.
So what happens, a person is able to come before a judge, and the judge will look at a number of things and make a determination. If the judge does not feel rehabilitation has occurred, that individual will remain where they are. If there is, the judge will be the ultimate arbiter of that decision.
Okay. Thank you. Good to see you. Thank you, Mr. Chair.
Thank you very much, Senator. And Senator, I fully believe that you all wreaked havoc in the Senate. I believe that to my core. No, Ms. Haskins, you've appeared here before us before, and I just want to say thank you for again coming back and your continued advocacy. We're about to have, the opposition panel will come up, and when we wrestle with issues like this, I thought, in this morning we had that discussion in the Black Caucus, and I thought fully in support of the notion of this bill. Obviously, we've taken action on this bill before, but one piece of the equation that you always have to keep top of mind is the victims' families and the victim.
Right.
And one part of that kind of the recompense is for the offender to fully acknowledge and accept and fully look into the eyes of what they did and hold themselves responsible. That's the first step.
Right.
And so as we, move through this process in this bill and other bills, just understanding that when folks come before us, it's important for, especially folks that are coming out and are reformed, to just fully acknowledge that, because there's one thing we miss, I think, in this committee is enough talk about the victims and victims' families.
Right.
And there's a balance, Senator Hens, you talk about this balance, but obviously, you've got to balance and acknowledge the pain the victims' families have gone through, while also understanding that we are in dire need of reform in our system. So I appreciate this. Looking forward to the continued debate. And with that, we're going to switch over to the next panel. We now have signed up in opposition Mr. Schellenberger and Mr. Wolfgang. Yes, Collins. So we switch over. Okay.
No, actually, legal first.
Good afternoon, Mr. Chairman. My name is Dawn Collins. I'm a wife. I'm an American. I'm a patriot. And my son, Lieutenant Richard W. Collins III, was third-generation military. I'm also a mother with a shattered heart. My son, Lieutenant Richard Collins III, became a commissioned officer at Bowie State University, a historically Black college and university, producing exceptional scholars, educated, dedicated servicemen and women. My son, Lieutenant Collins, was murdered at a predominantly white institution by Sean Urbanski, a student at the University of Maryland, College Park, and a follower of white supremacist ideals. I am urging all lawmakers to oppose SB 291 and the no limits approach of this bill and how it would benefit mass murderers, serial rapists, child sex offenders, and those who have committed hate crimes like the one that took my beloved son. There are a number of things that didn't make the process of grieving our son an easy or any less painful. At the time of Lieutenant Collins' murder, hate crime, laws in the state of Maryland were inadequate. There was no victim or victim-centered conversations. Excuse me. Okay. There wasn't any compensation consideration for supporting families involved in these tragedies. My son, Lieutenant Collins, told me that the world would know his name one day. His murder was not the way of hate crime, was not the legacy he or our family wanted to be left with. But, excuse me again, but here we are, doing what we can do to stand up, speak out, and call out injustice. The bill would undermine the small justice that was given in the case of my son's murder. Again, small. Because see, we live with this every day. Every day I wake up. So I need to be able to continue to know that my son mattered. My son was giving his life for this country, even the murderer. So please, for the sake of families across the state of Maryland, still grieving, recovering, and trying to make meaning out of the events that will forever change their lives, oppose SB 291. Thank you.
Good afternoon, Senators. My name is Kurt Wolfgang. I am the Executive Director of the Maryland Crime Victims Resource Center, and I am old enough to have been around to help it be founded almost 43 years ago today. I have submitted written testimony. I want to hit a few high points, and one of them is the victims who wanted to speak to you today, and we understand your rule and we understand the imposition of the rule, but I would like to call their names, and if you would stand as I call your name. These are all victims of murder, survivors whose family members were murdered. Deidre Jackson, Linda Mercer, Melody Monroe, Joyce Conyers, Lucretia Washington, Gloria Luckett, and of course you've met the Collinses. I would also like to ask those of you who came in opposition of this bill today with the Maryland Crime Victims Resource Center to please stand up. Wish I had plenty of time to refute some of the testimony you've heard today, but I want to also say that I understand that people who are in favor of this bill are motivated from compassion. We understand that. I'm urging you to reconsider and say that it's misplaced. You have to save some of your compassion for these people. to put them through more than what they have already gone through is wrong. I have had clients that have had 23 times that they've had to go back to court to try to keep the person who murdered their family member in prison.
All right, Ms. Wolfgang, I'm going to start giving it a little bit more tight on the time. I just wanted, out of fairness for all the witnesses, thank you very much for your testimony. Mr. Schellenberg, you're up next.
Yes, sir. Thank you.
Mr. Chairman, thank you very much. I'll go quick. So I'm joined today by State's Attorney Richard Gibson from Howard County. He's here today. What you just saw Ms. Collins go through, she will have to go through every 3 years if you pass this bill. After 20 years, every 3 years, she'll have to go to a courtroom and tell a judge the story she just told you today. That's what we will be doing to her if we pass Senate Bill 291. But let me tell you about another case, and I'll go very quickly. There's a man named Alfonso Hill. Back in 1983, a woman was violently raped in Baltimore City. I'm allowed to say her name because she's very public. Her name is Laura Newman. Her case went unsolved until 2002, when Baltimore City was able to relook at the case and find the fingerprints and convict Alfonso Hill as a rapist. He got 15 years in jail. In 2008, because of DNA, we were able to link him to another eight rapes that he was convicted of and got an additional 60 years. And in 2010, we got another hit with DNA. He had raped a 14-year-old girl in 1989 and got 30 more years. Alfonso Hill is currently 73 years old, and he's been in jail since 2002. If you pass this bill, next year I will have to contact 10 victims and ask them to come to court. And because I knew 3 years ago we hadn't found all his victims, we put a chart together of all Alfonso Hill's victims. I gave him immunity for the remainder of the cases, and he admitted to committing 24 rapes. 24, 10 convictions, another 14 people, and they will all have to come in court 3 years, every 3 years, and speak like Mrs. Collins.
Thank you.
Thank you very
All
much.
right, questions from the committee?
Thank you for your consideration.
Thank you. Questions from the committee? Senator Folden.
Thank you, Mr. Chair. So, thank you. I just want to apologize to the Collins family for not being here during your testimony. I apologize. I wanted to be here, and I didn't make it back in time. But I do keep with me the very card you gave me, and it's sitting right here in front of me about your son as a reminder, because it's important. And what I want to know is we had a bill similar to this the other day, and Ms. Schellenberg, you can answer, about geriatric and medical parole. And this is this would be, but I think this is even worse, because the geriatric and the medical, at least, I'll just say, they were talking about reuniting them with their loved ones and letting them die with someone there. And I brought up that, well, your victims didn't get to die with their loved ones. They didn't get to be reunited with them and in their arms when they died. So why should this person? And I thought that was an important point. And the other part is the re-victimization. And I spoke with the Collins family briefly about that, and I find it wholly inappropriate and wrong that we're going to put legislation in once again that is going to re-victimize the victims and make them come back in and relive it, because they live it every day.
Yeah.
Mrs. Collins and Mr. Collins, there's not a day that goes by that they're not re-victimized, that they're not thinking about their lost child. So I guess because of the type of the offenses that we have here, I'm having a hard time bringing this together, but is there something that Give me a good reason. There is no reason I can find to support such a measure where we're re-victimizing victims once again, and we're putting a bill in that looks to, once again, be lenient to those that are preying upon our communities. Is that?
Yeah, so I'm not particularly in favor of medical or geriatric parole. However, the difference there is that because of the age and medical condition of the defendant or the inmate, you have at least some assurances that the individual won't reoffend. But under the 291, the way it's drafted, if you commit a crime when you're 18 or 21, you're getting a look back at the age of 40. And if it was murder and you got life, you're coming in at 40, 43, 46, 49, and I can keep going. And every one of those hearings, Mrs. Collins and family will have to come into court. So there's a very big difference between medical and geriatric because of the age of the particular offender.
And Mr. Schellenberger, that brings me to an excellent closing loop. It's almost like you were reading my mind, but you know, we had a parole and probation agent killed May 31st of last year.
Yes.
That subject had been convicted of child sexual serious crimes, had been incarcerated for 23 years, 25 years. He's out on parole for a number of years. At 52 years old, he kills that young 32-year-old agent.
Yeah, and
he killed him just checking up on him. During a parole, just be very clear on that. Killed him, rolled him up in a rug, stuffed him under the bed, and fled at 52.
And that's why I also oppose 291, because we have a parole system. And you've already made the parole system easier because several years ago we took the governor out of the parole system, who used to always be in it. So we're constantly taking away these checks and balances. And yes, you are correct. Interestingly enough, unfortunately, as a result of that death, parole agents don't go to residents anymore to check on their clients.
Well, they're supposed to still, but they haven't in 8 months. They've done no home checks in any community of any child sexual predator or any violent offender since that murder.
That's my understanding.
They have not made our communities are that much unsafe by the inaction of the leadership there. That's another bill. But I wanted to thank you. I wanted to point that out, that case specifically, and thank you for your time, and thank you all for coming to testify today, folks.
That is another bill, and that is something we will continue to watch like a hawk, because that was unacceptable, and I have a lot more to say on that that's not appropriate for a microphone. But Senator Muse.
Thank you very much. Hello, my friend. Just one question. Don't the various post-conviction avenues almost all deal with challenging the constitutionality of the conviction, while second look allows for sentence change based on rehabilitation? Is that correct?
Well, not really. So a post-conviction usually will involve a lot of different issues, but the main one is typically ineffective assistance of counsel. And so while that doesn't rise to the level of a constitutional issue, certainly that's something that will get to the heart of whether or not the person had a fair trial or not. And then obviously, things like post-conviction DNA testing, the writ of actual innocence, they all go directly to making sure we got it right, okay? And so the legislature has already put in a number of safeguards, and the Rules Committee and the Supreme Court has made sure that you have all these other ones. And you know, I know people like to call this the Second Chance Act, but what I call it, if you look at my written testimony, is the 14th Look Back Act. And it's the 14th time that a victim like Mrs. Collins is going to have to come to court. And not just once, but every 3 years if we keep it the way it's drafted.
Thank you, Mr. Chair.
So back in 2004, the Maryland Rule 4345 was modified. Prior to that modification, would you say that what this bill is seeking to do, we used to do here in the state of Maryland?
Well, they used to require that the motion for modification be filed within 90 days. And many lawyers in serious cases would file the motion on the 88th day and ask the judge to hold it sub curia. And there were times when it was being held sub curia for 20+ years. And then they would ask to be brought up. I mean, another problem with all of this is...
Just so that I'm clear with your response, the answer is yes?
Yes, it used to exist, but the Rules Committee and other bodies decided that it was unfair to victims of crime that they should be, not knowing what's going to happen for so many years. And again, that's what the parole system's about. And of course, I came in here and testified, don't take the governor out of parole, and I lost that one too. And so we've already loosened up the system to make sure that the right people are getting out when they are. But, with all these extra acts and motions, I mean, there's a time where we should be able to say to Mrs. Collins, it's over. You don't have to come to any courts anymore. You don't have to face another thing. And the other thing that's important
Let me ask you
most
this, though.
judges aren't on the bench 20 years later.
Let me ask you this, though. With this rule, what did the rule change do?
It said that you can file the motion for modification within 90 days, and then within 5 years, the judge has to make a decision.
5 years, okay.
Do you want to talk?
Senator, there was a delegate by the name of Brown who had a bill in to cut down the period of time to 3 years.
Right.
Okay, and the Rules Committee, it was sort of a compromise. My organization was behind that change. And it was behind that change because of the abuses that were taking place. The people who were being released long after, and in some cases in inappropriate circumstances, in the sense that there were deals being made even at the time of sentencing, that they would bring them back later and diminish the sentences and things of that nature.
Let me ask you this. Under the old Rule 4-345, and if you don't know this, you can say you don't, but were judges releasing people willy-nilly, and that increased the risk for citizens outside in terms of public safety?
Probably Mr. Schellenberger might know that better than I do.
I'm just trying to understand, did the sky fall back then?
I don't believe judges in the state of Maryland, particularly in serious criminal cases, do anything willy-nilly.
They probably, if they sense or have any sense that that person is at risk, no judge wants to be on the front page having released someone and that person that they released committed some sort of crime, right?
And if the question is, isn't that so, the answer is yes.
Because they're extremely careful when these people come before them.
That's true. And what I'm saying is, it's not the release factor that's as important as it is the finality. There needs to be some finality. I need to be able to say to Mrs. Collins, it's over. You don't have to come to court anymore and tell your story to a judge who wasn't even in the courtroom 20, 25 years ago. It's going to be a new judge who has to learn everything all over again.
And if I might ask just one more question. Under the current system, under the current rules, is there a true finality even today?
With things like writ of actual innocence and the right to post-conviction DNA testing and some of the other ones that are listed in my written testimony, the answer is no. But that doesn't mean we should add not only another one, but another one every 3 years.
I appreciate it. Thank you, sir.
All right, further questions from the committee? All right, seeing none, that will conclude the hearing for...
Thank you for your consideration.
Thank you. The hearing for Senate Bill 291. We'll now move on to Senator West with Senate Bill 287. Senator West is under the weather and unable to attend today, so I'm going to read his testimony into the record, and then we'll invite his panel up to testify. All right, so this is Senate Bill 287. A sad reality of our time is that there has been an uptick in anti-religious extremism, regardless of faith. I believe that this committee and those watching this hearing would agree that Marylanders should not have to fear for their safety or property whenever they go or wherever they go to worship. They should have free and safe access to their chosen religious facilities. At the same time, religious facilities should have the right to exclude from their premises people who are regarded as threats. Senate Bill 287 adopts the same prohibitions and punishments the state has for preventing access or egress for a medical facility, as defined in Section 10201 of the Criminal Law Article, to religious facilities. This bill defines religious facilities as a place of worship, a cemetery, religious school, educational or community facility, and the grounds adjacent to them. The operative language in Senate Bill 287 states that a person may not intentionally act alone or with others to prevent any other person from entering or exiting a religious facility by physically detaining the other or obstructing or impeding or hindering the other's passage. The bill explicitly excludes the CEO of religious facilities or the CEO's designee or an agent of the religious facility or law enforcement officer. Anyone who violates the law will be guilty of a misdemeanor and fined up to $1,000. I appreciate the committee's consideration of Senate Bill 287 and will be happy to answer any questions the committee may have. Right now, we'll bring up the senators panel. So Ms. Smirsky, come on up. Or Mickey, God, you know, I'm calling you by your maiden name.
You know what? No one has stopped.
You know, there you go.
It's been 5 years.
And Ms. Miller, welcome.
Good afternoon, Chair Smith, Vice Chair Wallstrecker, and members of the committee. I'm Sarah Mirsky-Mickey. I'm the Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore, all of its agencies, as well as the organized Jewish community of Greater Baltimore. Here today in support of SB 287. Like the chair said, this bill is modeled off a 1989 law, the year of my birth, for medical facility access, and it follows the same exact principles. It's been around for 35 years. It's done great. And basically, the reason we're bringing this is because in a time of incidents of protest across the country, it's important that religious facilities remain a priority and that people feel safe entering them. We've seen students at Hillels on college campuses and community centers and synagogues have access blocked, and it's been intimidated and fearful for those members. And for those reasons, that's why we brought this and asked for a favorable report. Thank you.
Nice to see you. Good afternoon, Chairman Smith and Vice Chair Waldstreicher and members of the committee. I'm Deborah Miller, the Director of Maryland and Government Community Relations for the JCRC of Greater Washington. As many of you know, the JCRC represents over 100 social service agencies, schools, and synagogues in the region. And I'm here today in support of Senate Bill 287, which prohibits someone from blocking access to or from a religious facility. One of our top priorities at the JCRC has been protecting the safety and the security of the Jewish community. We work to condemn and combat anti-Semitism, which today, as many of you know, has reached unprecedented and unacceptable levels. According to a new report from the ADL Center on Extremism, hatred toward Jews not only spiked after the October 7th massacre in Israel, but the level of violent anti-Semitism has yet to return to pre-October levels, indicating a new higher and more dangerous baseline. Violent, strident anti-Semitic tactics underscore the importance of this bill to ensure that our community is safe, whether it's at a synagogue, a hillel on campus, a religious school, or Jewish community center. We have all seen protesters, as my colleague just said, across the country aggressively block entrances to Jewish facilities, instilling fear and intimidation. Last year, college students were attacked on their way to Shabbat services, and outside of synagogues, police have had to step up patrols when protests turned physical. The JCRC has been on the front lines of condemning this kind of violence, intimidation, and harassment, and we will continue to work to ensure not only that the safety of our community, but also the right to religious freedom, including access to all of our Jewish institutions. For these reasons, we also urge a favorable report for Senate Bill 287.
We have one more witness joining us virtually. Meredith, welcome. Good to see you.
Thank you. Apologies, I couldn't be there in person. For the record, Meredith Weisel, the Regional Director for ADL, the Anti-Defamation League, a leading anti-hate organization. I've submitted my written testimony, but I want to just highlight a couple quick things. So faith communities across the nation have been encountering increasing levels of hate-based incidents. And if you look at the latest data from the FBI, the 2023 FBI report revealed that faith-based hate incidents surged from 2,042 incidents in 2022 to almost 2,700 incidents in 2023. So this is an issue impacting all faith communities. And in Maryland, religion-based hate incidents saw a significant rise, going from 316 incidents in 2023 up from 105 in 2022. And that is a report coming out of the Maryland Department of State Police 2023 hate bias report. And so nationwide, we have been seeing incidents of individuals of their faith who are afraid to attend their houses of worship, who are not having the legal protections that are necessary. And so when you look at this proposed legislation, it is crucial to put in place legal measures that ensure that our individuals can access and exit religious facilities without fear of interference. This is really important to safeguard our fundamental right to religious freedom across the nation, and particularly here in Maryland. And so for those reasons, we urge a favorable report on Senate Bill 287, and we thank Senator West for introducing the bill.
So thank you very much. Questions from the committee? Senator Sidnor.
Can you square the people's First Amendment right to protest with this legislation?
So it's not stopping someone from protest. It's like if you are standing in front of an entrance to the building right beside, you can't block someone from entering the building. So they can lawfully protest.
But within the definition of religious facility, it includes the grounds, it says grounds adjacent to them. Not exactly sure what them is referring to, but.
So it's this, yeah, this is the same language that was used from the medical facilities from law that we passed in 1989. We can get clarification on that for you if you want, but normally it's, it's basically, if you're, so right, the entrance is right here, but if you're like to the side here and then you're moving here and then you're moving there.
I'm just remembering some years ago, there was a real distasteful organization that was going around and protesting at the funerals of people. I forget what, the Westboro?
Westboro Baptist.
Is that what they were?
Yeah.
And if you can correct me if I'm wrong, but I thought that they were allowed to continue their protests, right? They were not?
I mean, I'm familiar with them, but I'm not sure.
But with this definition of religious facilities, a place of worship, I get it.
Yeah.
But then it's a cemetery, a religious school, educational facility, or community center, and the grounds. So, all right, them refers to maybe a religious school, educational facility, or community center. Hey, that's what the them is. Let me ask this: on page 3, line 5B, says this section does not apply to, and it lists a number of people you're exempting. The chief executive officer of the religious facility to protest.
So
help me to understand what the intentions of that language.
So this is the same language pool. So it mimics the exact language from the medical facilities law from before. So if you look earlier in the statute, it just basically copies and pastes the same language to be cohesive with it.
Okay. So let's say that the pastor at my church said something that somebody didn't agree with. And they wanted to protest my church. How close could that protest occur and not breach this law?
Yeah, they can still protest. And Meredith, if you want to, it's about blocking an entrance. Yeah, that's fine.
So there is the way the bill is drafted, it says, if you look at section C, a person may not intentionally act along or with others to prevent another from entering and exit. So it's not a matter of just protesting, it's a matter of preventing people. And so the way, as Sarah was saying, the medical facilities, when you are blocking somebody's access, there is a distinction. So anybody, Westboro Baptist Church, hate speech is protected speech. We all understand that, but blocking access and somebody else's ability to access a religious facility is also taking away their right for religious freedom. And so that's the distinction, which is why this is crafted after the way a lot of the medical facility laws have been done.
And that would make sense if religious facility wasn't defined the way it's defined when you're talking about the grounds adjacent to them. Now, so again, if it's just a thing of blocking and trying to prevent people from entering and exiting, that's, to me, that's one thing. This seems to be trying to stop people from protesting something that they want to protest.
So the grounds adjacent to them, if you think about it, certain religious facilities, churches, synagogues sometimes have cemeteries next to them, which are the grounds adjacent, which is also blocking somebody from their religious freedom. It's not just the physical building, it is the grounds surrounding it as well. And that's why that is part of it.
Thank you.
Yep, of course.
All right. Further questions from the committee? All right. Thank you very much.
Thank
With that,
you.
that'll conclude. Hey, thanks. Thanks for joining us. Good to see you. That'll conclude the testimony for the proponents of the bill. We have one witness sign up in opposition. Is Ken Phelps here? Ken Phelps. Ken Phelps, come Phelps, come Phelps. All right, not here. That'll end the bill hearing for Senate Bill 287. We'll now go on to Senate Bill 333. Senator West, again, has an excused absence as he is under the weather. I'm going to go ahead and read his testimony into the record and then invite his panel up to testify. Under current Maryland law, a court may admit into evidence in a juvenile court proceeding or in a criminal proceeding an out-of-court statement that would otherwise be prohibited from introduction under the rule against hearsay evidence if the statement is made by a child victim or a child witness so long as certain criteria are met. First, the child must be under the age of 13. Second, the child must either be an alleged victim or witness in the case concerning a crime of violence or an alleged victim or a child alleged to need assistance in the case in a court case involving child abuse, rape, or attempted rape, certain sexual offenses, or certain other crimes of abuse or neglect. Third, the out-of-court statement must have been made to a physician, a psychologist, a nurse, a social worker, a principal, vice principal, teacher, school counselor, a licensed therapist, or a licensed counselor. Senate Bill 333 merely adds to the list of people qualified to testify about such hearsay in a court proceeding to a forensic interviewer. The term forensic interviewer is defined as a professional who is trained in child forensic interviewing procedures and techniques that allow for neutral, legally sound, non-leading, and developmentally appropriate interviews with children to gather information without influencing the information provided by the child. The term forensic interviewer does not include law enforcement officers, and under Senate Bill 333, the interviewer must be employed by or work under a contract with a child advocacy center. So, Senate Bill 333 merely adds a qualified forensic interviewer to the list of people who can give hearsay testimony in a court relating to statements made by children. This bill is a narrow way to ensure that we are properly protecting young people from the most heinous crimes, while ensuring that their testimony is credible and reliable. I appreciate the committee's consideration of Senate Bill 333 and will be happy to answer any questions the committee may have. Senator West. All right, we'll turn it over to Ms. King.
Thank you, Your Honor. Good afternoon. On behalf of the Maryland State's Attorneys Association, as well as the Child Advocacy Center in Frederick and the Frederick County Multidisciplinary Team, we ask this committee for a favorable report. This expansion, or clarification rather, to redefine what and who is a forensic interview is very important to smaller jurisdictions. As you all are aware, with the job market crisis, many CACs cannot afford or are unable to hire licensed social workers. We in Frederick are very lucky. Our child forensic interviewer is a social worker, and she submitted testimony via me, really stating that her social worker license is really separate and apart from her forensic interviewer techniques. And it actually is to her benefit, and she believes it is a greater benefit that she doesn't utilize her social worker status as part of her forensic interviewing. The forensic interviewer is an integral part of an MDT, and the role, it does not require this overlapping requirements and qualifications of a social worker at all. In many jurisdictions nationwide, that is not a requirement. And the issue with the state's attorney's offices bringing this forward is often we have victims that move away from their offenders to other states, and the CACs in those states are the ones conducting those interviews, and we're unable to utilize those interviews in our case here in Maryland because those forensic examiners, although qualified and as experts in those jurisdictions, it doesn't transfer here in Maryland. In Frederick County specifically, we had a 12-year-old victim whose her hair was grabbed, punched in the face, kicked, and tied to a banister. And her statements, because she did move away with her maternal aunt after being removed from that home, she was interviewed by a trained forensic interviewer in Virginia. However, that was not a social worker and psychologist, and therefore we could not use the statements given to that examiner. So for that reason, we asked for a favorable report.
Good evening. Scott Schellenberger, State's Attorney for Baltimore County, in favor of Senate Bill 333. So years and years ago, Criminal Procedure 11304 had been drafted and adopted that laid out the type of people that we allow these types of statements to, so that they can then say them in court. And what we're trying to do here today is just add one more step, one more qualification person to that list. Please remember, the very important thing is, under this bill and this statute, is the child must testify. So the child has to testify. The interviewer, forensics interviewer, is merely giving additional credence to what the child said, because it will be similar to what it was said before. And I took a look at the qualifications for a forensic interviewer, and I found that it requires a minimum of 72 hours of instruction, evidence-supported interview protocols, pre and post testing that reflects an understanding of the principles, understanding child development, have practical opportunities and a standard evaluation process, and they have to stay up to date and be current on all current techniques and articles. And so we think this is a very natural extension to things like physician, psychologist, nurse, social worker, principal, vice principal, teacher, or school counselor, and now we want to just add forensic interviewer. Thank you so much.
Chairman, my questions will reveal my, not being familiar with this process at all. So, but I read all the testimony that was available, and I was caught a little bit by the public defender's critique of the bill. So what I'd like to have explained is, it seems to me the list currently as it's composed, physician, psychologist, nurse, and so on, those people are not tasked with or assigned the job of interviewing this child specifically so that they can testify in court. I could be wrong about that, so I'm open to that explanation that public defender seems to imply that this is people that would have conversations with the child that may or may not end up in court, but they're there to help the child with the issue, not elicit information, and therefore it has, there's less manipulation potential manipulation or undercutting, the defendant's claim that this was a driven interview. So how would you respond to that critique? Because I don't know the history of the 11-304.
What I would say is that this forensic interviewer is going to have more training in this specific area than a doctor, a nurse, or even a social worker. So there are many doctors out there that may see a child who reveals some type of child abuse, and that doctor may not have any specific in-depth training in that particular area of doing an interview. Whereas this job will have a very specific training in how to do these interviews in a very objective and proper way. And that's what the goal is to get that kind of information.
I guess maybe you didn't understand my question. I got the sense, putting aside the forensic interviewer, that the list of people here, none of them are specifically tasked with interviewing this child to elicit information that could be used in court. What they're here for is a broader and less adversarial assistance, which is to talk to the child and give them help. Maybe coincidentally, the child will give a statement that would be permitted to be admitted under this statute. And that seems like a different category than a forensic interviewer, who I imagine they have a sole task with just to elicit information and to prepare it to go to court. So I'm trying to, am I wrong about that? If I'm wrong,
most
am I wrong
social,
about that?
okay, most social workers are the ones who work in our child advocacy centers. So the way that we do things in Baltimore County and many counties is a claim of child abuse is made, the team goes out, usually a detective in child abuse and a social worker. And that social worker will have exactly the type of training that a forensic interviewer has had. And therefore, they are also allowed under the law to do that. We're just trying to add one more category because there are some counties who can't meet these other requirements.
So you're saying that, yeah, I can't get you to give me a simple answer, but I'm just
explain your
you know what I'm saying?
Yes, I know what
and
you're
I do
saying.
see
Ms.
I
King.
see the relationship between a social worker, although I could be wrong. It seems to me a social worker could be assigned to this case to help the child, not. And in the course of helping the child, they're having a conversation, a statement is made, and the social worker would be in a position to provide that statement under certain strictures in the statute. But the social worker was not tasked with one and one purpose only: go out, interview that child, get information specifically that will be used to prosecute somebody. Am I wrong about that?
Correct. Yes, that's a misinterpretation. Okay. So currently, child advocacy centers exist. Social workers work within those child advocacy centers. What Mr. Schellenberger was saying is that when a child makes an allegation or there's a report made, the child is taken to those child advocacy centers already, where those social workers work. The purpose of those social workers there, and that's where the duality of their role is. Yes, they are there for the dual roles for advocating for the child, but they are also trained as forensic interviewers to separately, and how a forensic interview is conducted is that it's child-centered, it's developmentally appropriated, you're not asking leading questions. We want to minimize all the risks for suggestibility. And most importantly, these interviews are recorded. And so during an 11-304 hearing, we play these for the court, and the court needs to make those types of determinations to make sure and ensure the neutrality.
That's very, very helpful. Thank you. And then the other question I had was, there is a definition of forensic interview. Could you just, in the bill, so I just don't know where it is, right? Well, let's put it this way.
Yes.
I read Senator West's testimony. He said they are defined, and I was trying to find that definition.
It's page 1, 19 through lines 19 through 22. Or it's
what? 19 through 20. Okay. Is it? I'm blind, I guess. You're saying there is a definition of forensic interviewer in the new language?
Yes, new language.
And what line? 2 on line what?
19 through 22 is what I have.
Mine doesn't. It's weird. Oh, no, I got you. It's page 1. Never mind.
Yes.
Page 1. Okay. So then the need you're trying to fill is that in some jurisdictions,
They're not licensed social workers. So they have a forensic interview there who is qualified, trained, capable of making the interview, but they don't have a LSCW. They're not licensed. So, and they can't afford to be licensed, and these jurisdictions can't afford to pay them as a social worker. So that's why they're still
so then
admissible.
my last question is, as Mr. Schellenberger said, a very important criteria in the bill is the child will still be testifying, right? So, and I guess the child is under the age of 13. Is that a requirement too?
No.
No, that's not. So when are these statements, and give me a sense of when these statements are admitted. You have the child testifying. What kind of?
Because often, I mean, these statements usually, I mean, these statements are very valuable because usually they're being made more recent in time. So by the time we get to trial, it can be 3-5 years later.
Okay.
So it's impactful for the jury to see the child closer to what it happens. And as well
for anybody, but is an element because of the youth of the
Yes.
victim, their memory, language. I know, just trying to preserve that moment.
Yes.
Because there's a big difference between aging 5 years from 40 to 45 and 9 and 13. Is that the
Absolutely.
Is that the purpose of it? All right. Thank you, Mr. Chairman.
The rest of the witnesses are not, or have long departed? Okay. That's good. All right. I mean, not good, but, and then we have 3 people signed up in opposition. Is Ken Phelps here? And then we have Mustafa, and that's virtual. And then Ms. Taylor, you're here. So let's do Ms. Taylor first, and then we'll do Mustafa afterwards.
Hi, good afternoon, Chairman, and those of you who remain. Good to see you. I am here in opposition to Senate Bill 333. One of the reasons why we're in opposition of 333 is that this forensic interviewer is defined in the statute, but there's nowhere in Maryland statute regarding professional positions that it is defined. Social workers are defined. Social workers have licensure. Doctors are defined. They have licensures. And the same nurses have licensure. Social workers, principals, counselors, it says in the bill, a counselor licensed or certified, a therapist licensed or certified. And you also need to know that these are multidisciplinary teams. These teams don't just have one person. These have 5 or more persons on these teams at these centers. They're called multidisciplinary task force, and they're teams of individuals. This bill seeks to add an individual who we don't know their professional criteria. We don't know what education that they have. This is just anyone that works. It says that they're trained, hopefully they're trained by the center, but that they are employed under contract. Not that they have any particularized professional or educational training in order to conduct interviews on our most vulnerable citizens, children. We do not believe that this is an addition that should be made to the statute regarding tender years because it is a continued expansion of the tender years exception to the hearsay rule. And that's what it is. It's an exception to the hearsay rule. And every year or every other year, people try to add additional people. This is a person who we don't really know their professional criteria or their education and training. We are led to believe that these centers are doing the necessary training of these individuals.
Excellent. Thank you very much. Now I'll hear from Ms. Stopa. You're still on mute. Sorry. Here, hold on. Something should pop up on your screen in a second.
She's still on mute.
Here you go.
Good afternoon. Oops, now I don't know what happened. Good afternoon. I'm Tamara Stofa. I'll see if can you hear me?
We can hear you. I think your camera's off, but we can hear you.
Okay. I'm Tamara Stofa. I'm the district public defender for the Upper Shore. So I'm an attorney and a district public defender that works in those small counties. And I would echo what Ms. Taylor said. The previous witness that testified in favor of this listed a tremendous amount of qualifications that he indicated that a forensic interviewer would have to have. This statute does not reflect that in any capacity. And as indicated, all the witnesses that are currently allowed to testify are someone that is licensed, or someone that has been trained and qualified in this particularized area. I would also indicate that in my experience, it does not take 3 to 5 years to go to trial, even especially in these smaller jurisdictions. So I think that was an inaccurate, at least where we are, if this is the purpose of this statute. Additionally, I would indicate that our local advocacy centers share resources among our different counties. So there is an opportunity. But most importantly, I think the educational requirements are not specified in here as for a forensic interviewer. There is no reason not to have a high quality interviewer working with a child when we're allowing a hearsay exception to occur, such as occurs in this particular circumstances. And so for those reasons, I would ask for a non-favorable finding.
To either of the opponents, I think point well taken about there being absolutely no, specificity about the training. So my questions would be, if we did come up with, sufficiently specific training requirements, would that allay your opposition? And then secondarily, I don't know if the profession of forensic interviewer is elsewhere in the country, and we could look for some guidance elsewhere. So those would be my questions, and you can certainly follow up after the hearing, but that's what I'd be interested in. Thank you.
Do you want to respond? I would just say, again, the current professionals that can testify are licensed. There are boards that you can go to and have complaints with. A forensic interviewer, they've indicated to you, would not be paid as well because they're not as educated. And if there's a certification, who pulls their certification?
Point taken. I'm trying to figure out if there's a way to get that kind of training. Did you want to?
We would have to see what that criteria is, because right now this is not
right
a criteria. It seems like it's a job description.
Right. All right. Thank you.
All right, further questions from the committee? Seeing none, thank you very much. Good to see you both. All right, with that, that'll conclude the hearing for Senate Bill 333 and our hearings for the day. We are kind of light on attendance here just because a number of people have excused absences and a number of other senators have just a lot of work to do out of committee. So we're going to postpone voting until tomorrow after hearings. We're going to start bill hearings tomorrow at 10 o'clock. I don't anticipate the voting session to last long, and we have 9 bills tomorrow, 3 of which are sponsor only. So God willing, we'll get through it expeditiously, but otherwise we'll reconvene, and I'll see you guys tomorrow at 10 a.m.